We are following breaking news at this hour. We're going to interrupt our regular programming to bring you the closing statements in the Karen Read murder trial. Each side has an hour to present their final arguments.
Karen Read is accused of backing her SUV into her boyfriend, John O'Keefe, and leaving him to die in the snow outside a home in Canton. Right now, we're seeing members of the O'Keefe family who are there in the courtroom right now. Judge Beverly Cannoni just went into the courtroom right now. Let's go ahead and listen to see if she's speaking to anyone right now. Okay, we don't have any audio in there just yet. So we're going to go ahead and stay with these pictures. Right now, we do want to bring in our legal analyst joining us, Martha Coakley with Foley Hoag. You're also the former Attorney General of Massachusetts, as well as the former Middlesex District Attorney. Thanks so much for being with us this morning. And you're going to be here following along with us as we listen to these closing arguments here. Of course, as we just mentioned, each side has 1 hour. Yes. And let's go ahead and start with the first question for you here. How unusual is that, or is this probably right around the time they would be keeping anyways?
For a trial of this length with this many witnesses, an hour is about right. And that's about as long as most state court trials allow for a closing. But it's not unusual, I think, for this trial to allow each side to have an hour.
Could you give us some insight for our viewers as to what we can expect this morning? Right now, the judges entered the courtroom, but we're waiting for the jury to come in and be seated. What then happens as the proceedings get underway, and what can our viewers look for as the morning progresses? Sure.
Well, once the jury is seated, I think they'll go right into the defense closing. In state court, the defense goes first. They may or may not take a break, but if they have an hour and use it, they'll probably go for coffee. Prosecutor will come in after that and use as much of the hour if this he or she needs to do. But as the openings were a roadmap, these arguments are the summary, your best case. You're going to pick the evidence that you think helps your case to convince the jury of the charges if you're the prosecution. And if you're the defense, you're going to want to highlight the holes you've poked in that case. Where's the reasonable doubt? What can they put together in a story to find that some or all of what the defense says is accurate? Each side is now taking its last shot to convince the jury, frankly, that they're right and that either Karen Read is guilty of something, and we can talk about that later because they have choices on that, or she is not guilty, and they will say that and say no more.
Before we get to that, we're talking about the closing arguments and basically each side kind of connecting these dots.
Yes.
That we've heard 29 days of testimony. Is the jury going to hear anything that they haven't heard so far over these last couple of months?
They shouldn't.
Okay.
They shouldn't. Part of what the closing cannot do is go beyond the evidence. And so they may use charts, or they use a lot of video and other material during that. They may point to that in addition to their argument, but it has to be based on what the jury has heard or seen so far.
Okay, so let's stick with that then. How much can a jury be swayed in these closing arguments? Does the jury come into this box on this closing arguments day already with their mind made up based on what they've already heard? Or is there some real power in these closing arguments?
So both could be true, Doug, that people have a sense of where they're leaning and what they think. But remember, they've not been able to discuss it with each other. And the closing arguments can have a big impact on either side.
If you're wondering about why the camera went off up to the fan, the famous fan in that courtroom, it may be the fact that the jury is actually coming into the courtroom.
So they want to make sure it's not,
nobody
not
is
shown on
seen,
camera.
right? I think we have a picture from outside, live pictures from outside that courthouse. So just to continue on your point, Martha, you were saying that there is some room for flexibility and some swaying of ideas when it comes to the final verdict.
Absolutely.
On these
closing arguments? These closings are really important. You know, the openings can be important and provide roadmaps, but the closings can be really crucial, particularly if people are undecided, which jurors may not have made up their minds yet. They shouldn't have. And most importantly, they have not talked about it with each other.
Is that why they haven't made up their minds yet? Because I know a lot of people that are home watching have already made up their minds. And that's the difference between being at a courthouse and watching it in the comfort of your living room.
Yes. And of course, those watching at home, even though they say they saw gavel-to-gavel coverage, really did not. But there's two parts of this. One is sitting at the trial, and the other is the jury together reaching a verdict. That's the unique piece of this. So whatever people think may happen on this, they may well be wrong.
And that's the thing. We were talking about this earlier off the air, that this jury, they've been sitting next to each other several weeks, but they have not been able to talk to each other about this. That's something really important to keep in mind. For as much as we all talk about this, how much the general public is talking about this, all that really matters at this point after the closing arguments is what this jury thinks. And this is finally going to be that moment where they get to hear from one another what the thought process has been. Maybe we've seen, well, our reporters in the courtroom have seen a little bit of body language out of them, but really, so far, we have not heard anything. So this is going to be the evidence, the testimony, and what the jury thinks about that.
Absolutely. And that is unique in the American system, by the way, to have that, which is why there's such importance on making sure at the beginning and the end of the day, they're told, don't go on social media, don't listen to Channel 5, because it is important that they only make decisions based upon their common sense. Don't forget, they don't leave that at the courtroom door. Their common sense, but the evidence that's presented before them and how they put it together. And they know a lot about each other. I'm gathering they've bonded by now because they can talk about who they are. This brings people together that didn't know each other, but they will bond as a jury, which I found very often happens.
What are those dynamics like in the jury deliberation room? We always think of the movie 12 Angry Men,
Yes.
and how that works, where one person can have and maybe sway an entire jury. Is there that kind of dynamic? And just to preface that, how do they go about selecting a four-person?
So the judge will pick a four-person, presumably randomly, but not always, who will be really the manager, is not supposed to be unduly influencing others in their decision, but just to arrange, how are we going to do this? And jurors, some take a poll, right, when they go in. How many think guilty, how many not? And if they're somewhat evenly divided on guilty, not guilty, that's going to be a longer discussion where they are supposed to talk to each other about why they think that. And the people who think she's not guilty will raise, well, this created reasonable doubt for me, or these things created reasonable doubt for me. And others will say, on the prosecutor who think that she's guilty, will point out the strength of testimony, forensic evidence, whatever. And there's a real exchange with jurors, at least initially. I think it's unlikely that a jury with a case with this much evidence, these many sets of testimony, will come back too quickly. It is possible. By Friday, my rule of thumb always was for a week of testimony. And remember, weeks in this case were often 3 days or 4 days. But for a week of testimony, the jury will take, a day, half a day or a day to deliberate. So today's only Tuesday. They may start deliberating this afternoon. They could come back by Friday, but it could be longer than that.
And go
Speaking
ahead.
of this jury, we know that there are 15 jurors at this point.
Yes.
12 will be chosen to deliberate. How does that process happen? And when are they chosen? What happens to the other jurors during this process of deliberating?
So for the 3 who are not chosen to be jurors, they will not be chosen until after closings. So everybody listening to these arguments and the jury instructions knows that they better pay attention, because they could be one of the deliberating jurors. The other 3 will be segregated in case someone gets sick or there's an issue. And if someone has to come back in, that will be a further delay, because they are instructed that you have to start over.
You start the deliberations all over
if
again.
there's a new juror, that's right.
I always find fascinating, too, and this is a part of court that people sometimes miss out on, is the jury instruction by the judge. And the judge is so specific in their language to the jury as to what and how they come to their decision. Explain how specific and how influential, or how that can drive a jury to perhaps a certain finding, because it is so specific, even based on all that they've heard during trial.
Yes. And the law piece of it is always, I think, can be difficult for the jury, because it's based on statutory language, it's based on cases, some of which go back several years. And many times you will hear a jury come back and ask to be instructed again on the
clarify.
element of this or that. Some judges, I don't know what this judge will do, will give a copy of the jury instructions to the jury, which can speed things up because they can go back themselves. But they often will ask, and this is where we will pay attention to questions because people like to read those tea leaves. What are they talking about by that question? Often for instructions on a particular element of a crime. So keep in mind, these jurors could decide not guilty. That's the end of it. If they think she's involved or responsible, then they have other choices to make, right? Which crime? And you will get some sense if they ask for instructions on one, either the manslaughter or motor vehicle homicide, what that's about. So the instructions can be confusing. They often are a reason for an appeal on the case, but the jury does, I think, usually try to take that into account. What are these instructions? What are we supposed to know to do this?
So let's dig into that a little bit more, because the jury instructions, a big part of that is the charges that we're looking at here. We know, of course, there's a second-degree murder charge. There's also an OUI manslaughter charge. And potentially leaving the scene of a fatal accident charge. So is the possibilities here guilty, not guilty on each of those charges? Could she be found guilty or not guilty? Could she be found guilty of multiple charges? And are there other charges outside of those three that the jury can choose from?
Let's start with the last piece. They are limited to the choices that they have in front of them. They will have a slip that they all sign guilty, not guilty on particular charges. The easiest way to think about this is you look at the highest charge, second-degree murder, that carries a significant sentence. If she is found guilty on that, that encompasses many of the other lower crimes. There may be different elements on motor vehicle homicide, but by and large, if they can find her not guilty on the second degree, but find her guilty on one of the lesser charges that she is charged with, but they are pretty much limited to all of those charges. And then it's important for what they appeal on, it's important for sentencing, because each one of those will carry a potential different sentence.
Okay, it's 9:30 here on this Tuesday morning. If you're just joining us, we are interrupting regular program. We're just waiting for the lawyers and the jury to come back, or the jury to come in, be seated in the Karen Read murder trial, where we are expecting closing arguments from both sides today. And then it will be finally into the hands of the jury in this case. And for the last few minutes, while we've been waiting for things to settle down in court, we've been watching pictures outside of court. I would love to get your perspective and why you think this case has captured not only the local community of Canton and greater part of Massachusetts and New England, but some parts of the entire country have been dialed into this court on a daily basis. Why?
So that's a great question, and one place to go is in history, right? If you look at, first of all, homicide, some kind of homicide charge, whether it's the Lindbergh baby, to go way back even before television. Everybody was fixated on that case. Move forward with the advent of television. You look at O.J. Simpson, you look at the Louise Woodward trial that I was involved in. I think particularly when you have some elements, like a female defendant, a mother who kills her child, or a nanny who is accused of killing a child, and then you add in all these other elements that people are used to, frankly, from watching TV shows.
True crime is just such a huge thing right now.
True crime, and sometimes you can't make it up because the true crime is what's happening. But you have a romance that happened to go sour. You have the story of this victim here, John O'Keefe, who took in 2 children because his sister and her husband couldn't take care of them any longer. You have a potential breakup. You have all of these other players involved that night, but also before that, who knew who, what was going on here. And then you have, a very talented, aggressive defense that start saying, wait a minute, what about this? What about this? What about this? And so all of those elements make for what we're watching, all of the conflict. And as you probably know, most people aren't neutral about this case. They have decided early or now that they think, and I guess you could have three camps. One that thinks she is responsible for this somehow. One that says she never did it. And others may be in the, well, we just don't know. And the important thing here is the prosecution always has the burden beyond a reasonable doubt. And they will be told that, as they have been by the judge. So you can think about the ability for people watching this trial as they get involved in other kinds of drama. It provides a story, a narrative for people to say, wait a minute, this could happen in our town, this could happen to me, and it gets people very engaged.
And there's been this whole third-party defense theory also that people really have dived in on. They have their own theories. There's a lot of conspiracies that have been out there. And then just the fact that this whole third-party conspiracy, and defense theory involves potential corruption. That's another element of all of this.
Absolutely. Look, most of us at least grew up on Perry Mason. That not everybody here did. But that show every week was about a well-meaning but not very well put together prosecution, and the defense lawyer saved the day, right? I'm going to point out that the government was wrong here. And this idea that the government can sometimes make mistakes, can be corrupt, as you pointed out, is a real element that one of the reasons we provide counsel for people. And you want to make sure that people get a fair trial. And the burden's always on the Commonwealth. So if the case is kind of disjointed to begin with, this was not a straightforward case or a straightforward investigation. The case itself has been a little meandering in terms of what the jury's heard and the sequencing of what they've heard. So you can see why people are starting to draw their own conclusions or make their own summaries on that. But the important thing to remember is it's up to the jury now. And it will be interesting to see how long this takes, what questions they ask, what kind of verdict they come back with. And don't forget, they could be guilty, they could be not guilty, they could very well be a hung jury as well. Some people may think she's responsible, others will say, no, there's too much doubt here, or I think she's absolutely innocent. And others will say, we just don't know, or we don't know what charge. They could be hung on what charge she's responsible for, even if they think she's involved with it.
In your opinion, as a former prosecutor, the fact that this case had no eyewitness to the alleged crime here, there's been no video of the alleged crime here, how much of an uphill battle was this for the prosecution, and how much depended on all of these experts they brought in? And we saw a wide range of them. We just saw a few experts take the stand for the defense and then others for the prosecution. And their delivery styles, how much does that play into swaying the jury either way?
So all of those are great questions. And when you're not in the courtroom all the time, as we have not been, and you're not actually deliberating, that's part of what they will talk about. But the idea that there's no eyewitnesses, most crimes have no eyewitnesses, right? And people get away with it all the time. OJ. Most homicides don't have eyewitnesses. It's a little bit of a misnomer to say no eyewitnesses here. You do have eyewitnesses to a lot of what happened before, during, and after, as we've heard from witnesses here. The question is, are they believable? Were they right? Did they remember correctly when they told the jury what they saw or heard? And that's what this is about, sorting out who do we believe? Who has an incentive, whether it's a police officer or a witness, to maybe push their memories or to not tell the truth? The jury gets to decide that.
Speaking of the jury, we're just getting word that the delay currently right now in the courtroom is that the judge is having a discussion with one of the members of the jury. So that's what we're just kind of waiting on, for that to settle down before we actually go live back into the courtroom. So is this kind of a normal situation where the judge or a member of the jury at this point in the trial has something that isn't working for them?
It can happen, which is why we have alternates, and luckily we still have 3. And luckily this judge was wise enough to bring in 6 originally. So we're down to 3. It doesn't always happen, but it does. It could be as much as someone has a cold, or it could be someone has concerns about continuing further. We won't know, and we probably never will.
We actually want to go to our David Bieniek. He is on the phone with us right now. David has been in the courtroom. And David, you've been covering this trial from the very beginning. Can you talk to us about what exactly is happening in there right now? We saw the judge come into the courtroom a little bit ago, but then once again, we saw that infamous fan shot. So we know that there's something holding up these closing arguments.
Right, by now you've probably heard that the judge has questioned one of the jurors. One of the jurors was brought in and brought up to the bench for about a brief 5-minute conversation with the judge. We don't know the reason why, but the juror seemed to have a very determined look on her face. The judge asked her to step away from the bench while she continued speaking with the attorneys in this case, and then the judge asked one of the court officers to take her out of the courtroom. We do not yet know if this juror has been dismissed.
Okay, that's very interesting. All right, David, can you talk to us a little bit about the mood? We understand that several of the witnesses who took the stand earlier in the trial are present with some of the family members there.
That's right. Directly seated behind John O'Keefe's family is Colin Albert, Jen McCabe, Brian Albert, and Carrie Roberts. They were 4 witnesses in this case, and at least 2 of them, Colin Albert and Brian Albert, the defense has tried to implicate them in O'Keefe's death, saying that they might be the people who are in fact responsible. This is the first time that they have been back in the courtroom since their testimony on the stand, and they are seated right in front of me, just inches away as we're standing behind them and behind the O'Keefe family.
David, you've been really good throughout the entire course of this trial to give us a sense of what the emotions are like both inside and outside of the courtroom. Can you describe what the sense is inside the courtroom this morning?
You know, over the 2 months of this trial, there has at times been kind of like a jovial, not jovial, but perhaps just like a communal atmosphere where people have been relaxed and talking with each other. Today, it is completely silent. Nobody is saying a word. When people do talk, they speak in hushed voices. There's a very definite tense atmosphere in the courtroom today, unlike anything that I have seen during the previous 2 months.
Is it there that sense that we have now come to the end of the road where it's now going to be in the hands of the jury? Is that kind of where we're at then?
Exactly. Everybody in the courtroom knows that these closing arguments will be key.
We've seen a few shots of Karen Read there when they did have the camera on in the courtroom, David. Can you talk to us about her demeanor, her body language this morning? Are there any smiles? Is there just truly a lot of tension and a lot of waiting with bated breath in that courtroom right now?
When she came in, she did hug one of her friends or family members who were seated behind her, gave them a hug, and at times she's given them a smile, but she has been much more subdued today than she was yesterday. She left the courthouse almost jubilant yesterday after her defense rested with 2 defense witnesses, 3 defense witnesses, in fact, yesterday. She seemed very confident of a not guilty verdict. She decided in the end not to testify herself, but said that ended up being an easier decision than she thought it would be, again, for her not to testify.
We'll ask Martha Coakley what her thoughts are on that as well, about Karen Read deciding not to testify. But of course, this wouldn't be that unusual in these cases for a defendant not to get up there. Of course, we've seen that recently in some very other high-profile cases. David, hang in there. We'll check back with you in a moment. I know you've got a lot going on. So, Martha, to that point, the fact that Karen Read did not take the stand, I'm guessing you're not surprised.
I am not surprised. She has an absolute right not to do it. The jury will be instructed on that. That is sacrosanct in the system, as it should be. I didn't think that she would. And she probably didn't have a lot to gain by testifying. And remember, she can be cross-examined. Prosecutions always love it when a defendant takes the stand. I always did, because I would remind the jury that absolute right, Fifth Amendment right to remain silent. But once you raise your hand as a juror and take the oath to tell the truth, You are as any other witness. And if the jury finds you're not telling the truth or your memory selective, that could really count against her or any defendant. I don't mean just her. And this was a case where she didn't really have to testify in order for her defense counsel to do their work, it seems to me. So not surprised in general and in this case.
So no surprise that she didn't take the stand. But how surprising was it that throughout parts of the trial, we would see the day end, and sometimes she would speak about, oh, you know, maybe I will. I like to be outspoken. Or we hear from her defense attorneys after testimony for that day. How unusual was that, given the publicity of this case?
So I was surprised by that. And I think it's unusual in Massachusetts. And as we talked earlier, we have much stricter rules around all of this than, say, California does. And maybe we'll call it the Jackson influence here. He was pretty liberal with comments after a day in court. Prosecutors did not comment, as you probably noted. So it's a little surprising. Don't usually see it. And frankly, if you're the defense lawyer, you usually don't want your client saying anything in the court or out of the court. And clearly, they're not going to have her say anything under oath today.
Do you think that was a conscious effort to perhaps play this in the court of public opinion?
Potentially. I would think that could be the case, as with many trials these days. We live in social media, and so that is often the name of the game. So it could be that, but it certainly is a new trend. And I still think, you know, it's really important that the jurors not be involved in anything that happens outside the courtroom. Comments, whether it's by Channel 5 or editors or whatever, they really should pay attention to what happens in the courtroom.
Yeah, while there may be a court of public opinion, in the end, the only opinions that really matter at this point are going to be the 12 men and women who decide.
Exactly.
Do you think John O'Keefe has been lost in all of this?
To some extent, I think so, and many others have commented on that there is, unfortunately, a young man who's dead. Prosecutors in their closing, I think, will try to bring the jurors back to that. They will want to get the jurors to find some accountability for this, and I think as we talked at openings, this was not an accident by either side. Everybody agrees that somebody killed John O'Keefe, did not have a heart attack. And so now it's two competing narratives. What happened? And the prosecution has to prove its narrative, but defense really just has to provide reasonable doubt as to how else it might have happened. But in that contest, of course, and I know this is true for victims, we're about defendants' rights, we're about the trial, and often, you know, the victims in this case and their families do get lost, unfortunately, not just this case, but in other cases. But I think there's been some of that in this case as well.
And speaking about that, David Bieniek touched on it just a little bit. We talked about how some of the previous witnesses, some of the people who took the stand, are in the courtroom today, and they are on the side of sitting with essentially John O'Keefe's family. Was that a tactic by the prosecution here to have them be present in the courtroom? We haven't seen any of them except for when they gave their testimony, and also the fact that some of them are implicated by the defense in their third-party theory here.
So first of all, most people who were testifying were under an order not to be there, because we don't want witnesses also seeing what other people say or how testimony occurs, so that their testimony won't be affected by something.
So they couldn't be there.
By and large, that's true. And most of those folks testified. Once the evidence is over, they are free to come. It's probably their decision, not necessarily a prosecution. Won't have that much of impact on the jury, I don't think. You know, on the other hand, the defendant is often the case, has family, has friends and supporters in the courtroom. And it's an interesting issue because it can, over the course of a trial, have an impact on jurors. All those times where the fan is on or they're at sidebar, the jurors are watching what's going on. Who are these people? You know, who's in the courtroom? Because they don't have much else to focus on. And they do pay attention, I think, to who's sitting in the courtroom and what are they doing.
In most high-profile cases recently, there's been a lot of focus on the judge that has been in charge of the courtroom. And even going back to Judge Ito in the O.J. trial,
Yes.
how do you think the judge has handled this trial as a whole?
I think this judge has done a very good job. She's a former trial lawyer, which is always helpful when you're trying to manage a big, sprawling case like this with lots of evidence, active, aggressive defense counsel. I think she's done a pretty good job both on managing that and keeping the witnesses and the evidence. She's had hearings on whether experts can testify or not, called voir dire, to make sure that they're qualified and their testimony can come in. So I'd give her a pretty good grade for her management of this trial at this stage.
Okay. What about your grade on the prosecution and the defense here? We have watched this for so many days. We saw, let's call it a measured approach on the part of the prosecution, Adam Lally. There were a lot of drawn out conversations and talks and very, very detailed questions of his witnesses. And then you've got Alan Jackson on the defense side, who is just known for what he's known for, performing in the courtroom. Were there any big aha moments? I know we had talked about that inverted video. Did that play a huge part? Did either side really have their moment where you think they just really proved their point?
That Perry Mason moment, if you will, going back to
the Perry Mason.
Right.
Well, Perry Mason only had an hour.
Yes, that's
right.
As I used to remind yours, this is not Law and Order or Perry Mason. This is going to take a long time. It's not clear to me that there was one aha moment. For some of the jurors, there may have been a couple in terms of either the prosecution or defense, in terms of what made sense to them at the time. And I think that if the jurors started to lean towards the defense when some of those things happened, the reverse of the film on the car, something else that was inconsistent, they might have started to put those in a pile that said to them, this is all consistent with the way I'm thinking about this right now. And the same on the prosecution.
Not to cut you off, Martha, but just want to let people know at home that we understand that both the prosecution and defense are now going up to talk to the judge.
Okay.
Would this be based on whatever conversations the judge had with the jury in order to kind of figure out what's happening here?
Presumably, if she's been dismissed, which we don't know yet, they would then draw one of the three randomly to replace her. And that's fine at this stage because no one started to deliberate.
And they've all listened, all the jurors, all 15 that are left, have listened to all of the testimony. And even still, we have not yet gotten to these closing arguments. So all of them are going to be listening to the closing arguments. And then regardless, from this point on, if someone gets dismissed, they would be able then to start.
That's right. And that's why you don't designate the alternates ahead of time, for that very reason. So they're not going to lose anything if they have dismissed someone and someone else is put in. They're all going to be on equal footing going into the deliberations.
When it came to witnesses, there was not equal footing. Prosecution had over 60 witnesses. Defense had close to 6, if not just 6. What does that tell you about in their approach and why the defense didn't feel the need to do 1 for 1?
So this is not like a basketball game or a football game where, they have these many players and you only have this many, so we're going to win. It's not about the number. It's going to be about the quality of the evidence. And defense, remember, wants to be strategic. They don't want to just throw, I think, spaghetti against the wall and say, well, this may be doubt or this may be doubt. They have projected somewhat of a narrative that they have to provide some coherent narrative to also. Because remember, if someone is dead, jurors don't leave their common sense out of the courtroom. And they're going to want to presumably find who's accountable for it if they can. And so you now have two competing narratives. So the defense have to stick a little bit to what theirs is, cross-examining witnesses and putting on what they think are strategic attacks to create reasonable doubt, consistent with the theory that something happened in the house, he was bitten by the dog. We don't think the dog killed him, for instance, but it's just another factor that they're trying to say what the prosecution is telling you is full of reasonable doubt.
What is reasonable doubt? Is it a very individual estimation?
No, it is. It's not beyond a shadow of a doubt.
Right.
And
is there an actual legal definition for it?
There is, but when you look at the case law, it's just more sort of common sense
Okay.
evidence, whatever. There's no magic bullet. And there is this idea that the jury gets to decide at this time and place what is reasonable doubt for us. And if they find reasonable doubt and not guilty, that's the end of it. There's no appeal, there's no questioning of it. If there is a conviction, of course, what is reasonable doubt will go up on appeal. In other words, when the jury comes back, if they do the verdict, as in any case, the defense will say, well, there was reasonable doubt because of these 5 things. And a court above could say that's right, that we think the jury made a mistake here. Now, they give a lot of deference to what the jury decided, but this gets argued all the time.
And that would be a decision made by a court, not by another jury.
Correct. No, that's correct. The appeals court would look at whether the jury should have found reasonable doubt given all of these other factors.
And that's why we always hear that the burden is with the prosecution.
Yes.
It's not the defense's burden
Never.
to prove that she didn't do it. You're innocent until proven guilty in
That
this
is correct.
country. It's the prosecution's burden to prove their case.
Beyond a reasonable doubt. Right.
Right, and the defense doesn't even have to prove who did it.
They do not.
They don't. And, in this case, if, based on what the prosecution is presenting, that they believe that Karen Read did in fact kill him, John, then what happens in the event that if she's found not guilty, who killed him? Now, is that, again, I lean back to OJ, whereas the public has one viewpoint, the
Yes.
courts have another.
Yes. And it would then obviously be up to the district attorney to decide, did they totally get it wrong and they have to start all over again. That doesn't happen very often, and that remains to be seen, of course, what happens. And you had asked earlier about grades for defense counsel. I think I'm going to hold my grades till the end of this semester and see what the jury actually does, because the very different styles, as we noted. Some of the case went in more smoothly than other. It was I would say it was uneven in terms of the case going in, and in some ways on the cross-examination. But I will be curious to see what the jury finds, because in the end, you still have facts, evidence, common sense. Then you have the quality of the lawyers, the preparation, what they were able to do to influence the jury. And sometimes, and this happens on both prosecution and defense lawyer, one or other of the lawyers on either side could irritate.
That was going to be my question.
They could
personality
Yeah.
of either the defense or prosecutor. How does that play to the jury box?
And it's a good question, Doug, and sometimes it really depends, because the jury, your job as a trial lawyer is to get the jury to trust you, that you will be a good guide through this to help them make their decision. But if they start to think you're pushing too hard, or you're not pushing enough, they will start to think you're not a good guide, and they will start to then discount things you've said or done. And I don't know yet on either side what was not in the courtroom, so some of that we can read backwards after we get a jury verdict about what they read into the styles and what those lawyers did or didn't do in the courtroom.
Does that standard also apply to the witnesses in the case? We know both sides brought in different experts and whatnot. Does their demeanor, in the sense, just take, for example, the defense's last couple of witnesses. They seemed very knowledgeable, very credible. Could the jury potentially look at them and say, okay, these guys, they sound like they know what they're talking about, whereas someone else they might have previously heard from, I kind of wasn't following where he was going with what he was saying. I'm not sure. I'm actually kind of confused by what he was saying.
By the way, we've gone back to the famous
there's the
fan,
fan
just so
again.
you know.
The fan.
This just in, they're trying to figure things out again in court, but go ahead, Martha.
Yeah, absolutely. That the expert witnesses, of course, are chosen because they are experts. So you would expect them to be well qualified, to be good communicators, and to make sense in the context of the case, and that can vary. Now, other witnesses, the Commonwealth or the defense don't choose those. They don't choose who was going to be plowing snow that night or who the neighbors were, who was in the house. And so I think jurors will give them a little bit more leeway in terms of their memory, their motive. Do they have bias? Do they know people? All of that will come into play. But the experts are supposed to be separate and apart. But by the same token, the jurors can think they were too narrow in what they said, or they didn't make sense. And sometimes jurors are, and I'm not saying in this particular case, but jurors could be put off by experts who either talk down to a jury. I don't get the sense that anybody did that here necessarily, but you're exactly right that their demeanor and how they communicate is crucial for whether the jury believes them or not, or wants to credit their testimony.
We're continuing to keep an eye on what is happening outside the courthouse there in Dedham. We have just a couple of more minutes here. In a sense that what is happening with the delay in getting to these opening statements by the prosecution and defense, does this aggravate the jury at all, or perhaps aggravate the judge? I mean, we were supposed to get underway at 9 o'clock, and here we are pushing 10. How does that play for the jury right now?
Well, they've had a lot of waiting.
Yeah.
You know, every time there's a sidebar, they know that. And of course, they may know more than we do about what's going on with this juror.
Yeah.
So, yes, it is game time. We're ready for the whistle, for the final act here. I'm mixing all my metaphors between a play and a sporting event, but that's some of what this is.
It is
right?
Shakespearean, to say the least. This one has been, for sure.
Yeah.
That's right.
So just to remind our viewers that we are in this delay right now as we await closing arguments here in the Karen Read murder trial, that there has been an issue with a juror. Our David Bienick did report that a juror went up to the judge, had a very determined look on her face. That's what our David Bienick said from looking in the courtroom. They brought her out, but we don't know at this point if she's been dismissed. Martha, hold tight, because we are going to get to closing arguments as soon as they begin.
We'll be right back. Stay right here at Channel 5. Welcome back. We want to break into regular programming to bring you the closing statements finally in the Karen Read trial. Let's listen into the judge.
Again, we appreciate your patience. You may notice that one of your fellow jurors is not sitting with us today. I can assure you that that is because of an issue that is just personal to that juror and has nothing to do with any concern of any of you. So please disregard that, okay? I do have to ask you those 3 questions. Were you able to follow the instructions and refrain from discussing this case with anyone since we left yesterday? Yes. Everyone said yes or nodded affirmatively. Were you also able to follow the instructions and refrain from doing any independent research or investigation into this case? Yes. Everyone said yes or nodded affirmatively. Did anyone happen to see, hear, or read anything about this case since we left here yesterday? So now we're at the point of the trial where the lawyers get to do their closing arguments for you. I've given them each an hour to do so, and they both tell me that they want me to give a 5-minute warning. I just don't want you to think I'm scolding them when I give a 5-minute warning, so we'll let them do that. When I was a trial lawyer, I tried a lot of cases in this courtroom. The thing I liked least about the trial was just before I stood up to give my closing argument, the judge would say, jurors, remember, closing arguments are not evidence. But it's true. So because of that, you have to put your notebooks away. All right, so if you just put your notebooks away and just listen, and though the closing arguments are not evidence, they're certainly a very important part of the case. And you've all seen how hard the lawyers have worked for this long period of time. And we've all noticed that you've paid great attention throughout the entire trial. I'd ask that you extend your courtesy to the closing arguments. And in Massachusetts, because the Commonwealth has the burden of proof, the Commonwealth goes last. So we will hear now from Mr. Jackson.
Thank you, Your Honor. Look the other way. Look the other way. 4 words that sum up the Commonwealth's entire case. 4 words that sum up the hopes of those who have tried to deceive you. Conflicts of interest? Doesn't matter. Just look the other way. Magic hairs, magic glass. Look the other way. Late night calls and Google searches, falsified affidavits, inverted videos, and butt dials galore. Just look the other way. That's what they want. That's what they're counting on, but the uncontrovertible fact is you have been lied to in this courtroom. And your job is to make sure you don't ever, ever look the other way. Your singular duty is to stare down the evidence and do it unflinchingly and do it unwaveringly. You see, you're the only thing standing between Karen Read and the tyranny of injustice. It's a job you didn't ask for, probably a job you didn't want, but it's the greatest responsibility we have as citizens here in America, lest the government stop answering to us and we start answering to the government. And woe betide any one of us who might find ourselves in the crosshairs of a Michael Proctor. Preparing for today, I was reminded of a quote. It's a quote about the truth, and I want to share it with you. It is of great importance to set a resolution never to tell an untruth. There is no vice so mean, so pitiful, so contemptible, and those who permit themselves to tell a lie once find it much easier to do it a second time and a third. This falsehood of the tongue leads to that of the heart, and in time, it depraves all its good dispositions. What does that mean? It means that it's been observed that to tell an untruth, to exaggerate, to make a false claim, it's a cancer. One lie begets another, and it's a malignancy that grows over time. And that, folks, is how a cover-up is born. That's how a Massachusetts state trooper says in whispered tones to his friends when he thought no one was looking or listening, how he would make a case, how he would make it cut and dry, no matter the truth, how he would make sure to put, quote, serious charges on the girl. In other words, pin it on the girl. You may ask yourself, how does this happen? How could this happen? It's 2024. Surely people aren't going to come to this courtroom, this hall of justice, and lie to us, just give us false information. They wouldn't do that. They wouldn't try to cover up the truth. The Alberts, the McCabe's, Higgins, Lank, Michael Proctor, Yuri Buchanan, Brian Tully. You don't have to wonder if they would lie to support their narrative. You need only wonder how many times they did lie. Over and over and over, they and others were caught deceiving you. Big things, small things, it didn't really matter. They feared nothing. They'll look you in the eye and deny phone calls. They'll deny secret meetings. They'll claim that calls are butt dials and butt dials are answered. They'll show you a video and tell you left is right and right is left. They'll magically turn 3 pieces of plastic into 5 right before your eyes. And even when they're caught with their own lies, they won't blink, they don't sweat. They'll just look you in the eye and demand, pay no attention. You folks look the other way. Ladies and gentlemen, there was a cover-up in this case, plain and simple. You'll surely say to yourself, I don't want to believe it. I don't want to believe that can happen in our community. But sadly, over the past 8 weeks, you've seen it right before your eyes. So how does a cover-up happen? How could that happen? Well, let's count the ways, shall we? Handpick your investigator. Make sure it's someone we know, someone on our side. Keep him close. Offer him help. Offer him a gift. Have secret friends and family meetings. Get your story straight. Delete your call history. Make mysterious phone calls at 2:22 a.m. Delete Google searches. Monitor police activity. Get rid of evidence. Get rid of your dog. Destroy your phones. Destroy your SIM card. For the investigator, decide on a narrative early on. Don't go to the crime scene. Don't take witnesses in for questioning. Question all the witnesses together. Ignore witnesses who don't fit your narrative. Allow friends and family to contact those same witnesses. Don't record interviews. Write vague and false police reports. Omit witnesses' names. Omit witnesses' interviews altogether. Don't photograph the evidence. Don't conduct any forensics. Don't document the evidence. Don't document the logs. Don't create any logs whatsoever, and don't maintain a chain of custody. Keep all the evidence in the hands of one person and then manipulate that evidence, including videos. Don't turn over videos. Invert videos. Turn 4:16 p.m. into 5:30 p.m. in affidavits. Turn 3 pieces of taillight into 5 pieces of taillight. Delete 42 minutes of surveillance footage. Hide personal relationships. Make this case cut and dry and ensure the homeowner, quote, never sees any shit because he's a Boston cop. But most importantly, pick your patsy and pin it on the girl. It's not that it could happen. It's that every single one of those things I just mentioned did happen right in front of you. But this sort of injustice can't happen in a vacuum. So what about the prosecution? What about the Commonwealth? What does it look like when the government picks a narrative and then tries to form a prosecution around the narrative instead of the other way around? Looks a lot like this. If you don't have actual evidence, just throw every single thing you can against the wall to see what sticks. Drag her through the mud and make sure you attack her character. And that's what you saw in this case. The Commonwealth spent much of their time and resources trying to vilify Karen Read. They desperately resorted to calling witnesses to talk about Karen Read and John O'Keefe's arguments. They even stooped so low as to call the children and put them through this ordeal. All to say that John sometimes got upset because Karen was too kind, too nice, spoiled them too much. Their arguments illustrated what anybody could imagine is a normal set of ups and downs for any couple. Even on January 28th, they talked it out, they communicated, they worked out their issues, and they had a nice, affectionate evening out with their friends. And you don't have to take my word for it. Pull the tape, as they say. Look at the videos. C.F. McCarthy, Waterfall. What are the words that every single person who testified in this case used about Karen Read and John O'Keefe that night? Getting along, no issues, good mood, happy, affectionate, even lovey-dovey. No issues, no toxicity. They were a loving couple right up until the time Karen Read dropped him off and he walked into 34 Fairview. If an argument with a loved one is a motive for murder, folks, we're all in trouble. Speaking of which, what is the evidence that John went into the house? The Commonwealth will tell you, undoubtedly, no, he never went in the house. And they'll point to certain witnesses who they say didn't see him go in. Well, the question you have to ask yourself is, can you rely on that? First, these are all people who are related to or committed to the Alberts in some way or another. That all-powerful Canton family, it's easy to say, I didn't see something, because how can that really be challenged? Some actually may not have seen John walk into the house. They were in the kitchen, as you recall, from Nicole. Third, at least one witness, Brian Higgins, forgot his narrative, at least for a second, and he admitted a man did, in fact, come into the house. And then when he was caught and asked to describe that man, he had to. It was a little bit vague, but you remember what he said. He was tall, with dark hair. That was a telling slip of the tongue by Brian Higgins. But what's the real evidence of the unbiased data, the data that's not connected to the Albert family? How about John's Apple Health data? It shows that at 12:21 a.m., an important time, John arrived. That's established by the monotonic time clock that you heard about in this trial that was on his phone, and that represents a huge problem for the Commonwealth. It shows that he took 80 steps and ascended or descended 3 flights of stairs at that time. And that makes perfect sense, doesn't it? It matches. Walks into the house, goes directly to the basement. There's your 80 steps and your descending flights of stairs. The big problem for the Commonwealth is he wasn't outside at the car ascending and descending stairs, wasn't climbing on top of the car. So they'll tell you, wait, don't look at the Apple Health data, look at this other thing called Waze. But Rick Green explained that if you apply the 3-minute offset that is built into that monatomic time, it aligns perfectly. They don't want you to see that. They don't want you to pay attention. They want you to look the other way. But even more importantly, at approximately 12:32 a.m., someone holding John's phone takes another 36 steps and travels 25 meters. Why is that so important? Because by 12:32 a.m., Karen Read was gone. She had already left the location. She left at 12:30. Trooper Garino told you that Karen Read's phone connected to John's Wi-Fi at what time? 12:36. It is undisputed in this case that it's a 6-minute drive on a good day from 34 Fairview over to One Meadows. She was gone by 12:30, and John's phone was taking 36 steps and logging 25 meters at 12:32 after she'd left. So don't be fooled. John walked into that house, after which Karen drove away, and the scientific data all prove it. But also, Ryan Nagel and Heather Maxson prove it. In addition to the Apple Health data, Ryan and Heather both independently testified that they passed Karen's SUV as they drove away after talking to Julie, and Karen was alone in the SUV. John was not with her. He wasn't in the car. He wasn't standing outside the car. He wasn't sitting beside the car. He wasn't laying on the ground beside the car. He was nowhere in sight. There's only one other place that John could have been, and that's in the house. Exactly where the Apple Health data places him. So it all fits. And Ryan was right behind her, remember, staring at her taillights, undamaged, brightly lit. That brings up another difficulty for the Commonwealth, and that's their star witness, Jennifer McCabe. You'll recall that Jennifer McCabe claimed that she was looking out the door, staring at that SUV over and over and over again from 12:29 to 12:50. She was very specific about that time frame. But we know that the SUV was gone from 34 Fairview by about 12:30. Had to be in order to connect to the Wi-Fi at 12:36. So unequivocally, Jennifer McCabe was lying about watching that SUV, and it makes you wonder why. And to add to that deceit, she was also blatantly lying about the calls to John's phone. You remember that colloquy back and forth. She said that every single one of those calls to John's phone during that time was a butt dial. How are those lies connected? And why are they connected? Jennifer McCabe knows. Was she butt dialing John over and over? Or was someone looking for John's phone that went missing? Let's talk for a second about what actually happened in the time leading up to everyone going to 34 Fairview. Brian Albert, Brian Higgins show up drunk at the waterfall. They had been drinking in the afternoon. You know about the flirtatious texts that were sent between Karen Reed and Brian. Higgins was clearly pining over Karen, but for her, the flirtation had ran its course. It was done. She was happy and committed to John. You could see that in her actions with John that night. You don't have to guess. Brian Higgins, however, you can see in his actions, he wasn't quite so satisfied and he wasn't done. His text message, well, meaning, what the hell, Karen? What about me? Seemed aggressive, seemed annoyed. He didn't like being ignored. That was pretty clear. So he's 5 or 6 whiskeys deep into the night by this time, and she continued to ignore him. Then oddly, Higgins, who doesn't know John all that well, seems to want to coax John to 34 Fairview. I draw your attention to the waterfall tape if you want to take another look at it. It's at the 11:57 mark, between 11:57 and 11:58. Take a look at that tape. He's just about to leave. Higgins is just about to leave. He points over at John and he motions for him. Come on, come with me. And then at 12:20, he texts him, you coming here? This is a person he doesn't really know and didn't really talk to that entire night. Ask yourself, why was Higgins so insistent that John go to 34 Fairview that night? And then there's that sparring and fighting that he and Brian Albert were engaged in. Of all the things they could be doing, this is what they were doing just minutes before John O'Keefe walked into that house at 34 Fairview. We know that once John actually did walk in the door, it's about 2 steps, 4 feet or so, 2 steps for an adult male to reach that basement door. Remember, everybody was gathered in the kitchen. That's what Nicole Albert said. And every single witness agreed that at some point, Brian Higgins and Brian Albert left the group and went to another room. Where did they go? Where did they go together? Another important point. Chloe was not upstairs. Brian Albert slipped in one of his testimony that he provided. Quote, I was watching Chloe downstairs, monitoring her because of the other people in the house. She's not good with strangers. Remember that testimony. So what happened next? We absolutely know that John was in the house. The data, Ryan, Heather, they all established that. We know that John ascended or descended stairs. We know that Brian Higgins and Brian Albert excused themselves. How long does it take to have a crossword? How long does it take to have a fight? How long would it take for Brian Higgins to say to John, you know, your girl's been texting me. A push, a punch, a fall, pull Chloe off his arm, and now it's done. What is that? 5 seconds? 10? Doesn't take long at all. And then the panic sets in. It wasn't intended to go that far, but what's done is done. And then some very, very odd things start happening at the Albert household. Very odd indeed. What do we know? We know through the testimony and key swipes that Brian Higgins very oddly goes directly to Canton Police Department. Why would he do that? After a night of drinking and partying, why go to CPD when you're drunk? What was so important there? He couldn't even get his own story straight. First he said it was administrative work, then he said he was moving cars, then he said it was a factor of both. Is it both? Was it neither? Or was he there to gather intel? Ask yourself, why go? But the odd things keep piling up, and here's another. Chloe was the Albert family pet. Not only did she appear to be gone from the house that morning on January 29th, nobody saw her there. Even Jen McCabe admitted, yeah, I didn't see her there. But they actually got rid of the dog altogether. Within months of this incident, the dog was gone, out of the house, rehomed, never to be seen again. This was a dog they had had for 7 years. Also a dog who had a bite history. Why was it so important to get rid of that dog? Was there something about the dog they did not want law enforcement to find out? Recall what Dr. Russell said. She's seen up to 1,000 animal attacks. In her expert opinion, John's right arm, those injuries are from an animal, quote, most likely a large dog. And Dr. Russell's testimony, I'll remind you, was undisputed by any witness for the Commonwealth. But there are more odd and unexplained things. After a night of drinking and hanging out and partying, after being together for the entire day, at 2:22 a.m., Brian Albert decides to call Brian Higgins. That call was missed, but 17 seconds later, Higgins calls Brian back, and they speak for 22 seconds. Now, that call is odd and suspicious enough, in and of itself, the fact that the call was made. But what's even more incriminating is that both men, both of them, lied about the calls happening. They both claim astonishingly that those calls are, you probably say it with me, they're butt dials. Amazing. But Albert and Higgins take it a step further. Not only did they claim that they were making calls as butt dials, but they were answering calls as butt dials. And Higgins seemed awfully defensive about that call, didn't he? Remember on cross-examination when I was asking him, can you have a conversation in 22 seconds? He unequivocally said, no, that's impossible. It's not reasonable. You can't do it. Well, let's test that out. Hey, did you make it over to Canton? Yep. Haven't been any calls. Nobody knows a thing. All right, don't talk to anybody until we talk again. By the way, come back over. I need help moving something heavy. How long did that take? 15 seconds? Maybe? But the odd behavior isn't done yet. 5 minutes after that call that we just talked about, Jennifer McCabe is on her phone at her house, Google searching how long it takes for someone to die in the cold. That was at 2:27 a.m. That timeline seems to fit, doesn't it? And it fits a very telling and a very clear story. That search became a focal point of the Commonwealth's entire case. This case was starting to look a lot more like the defense of Jennifer McCabe than anything else. That's probably because there is no innocent explanation for that Google search at 2:27 a.m. None. At the end of the day, clearing away all the confusion the Commonwealth's experts were left with two things that are true. First, neither of their experts could absolutely rule out that Jennifer McCabe made that search at 2:27 a.m. Neither. And second, the only person to use the actual phone model, the actual data, and the actual precise operating system was Rick Green. And he was clear. That search was at or before 2:27 a.m. And then it was deleted. So what else was going on at or around this same time when all this suspicious activity was happening at the Albert house and the McCabe house? 3 minutes after that search and 8 minutes after the Albert Higgins 2:22 a.m. call, Brian Loughran drives down the street in his snowplow. And he told you that there is no body laying on the lawn at 34 Fairview at 2:30 in the morning. Importantly, he didn't just simply say he didn't see a body, he wasn't paying attention. He said there was no body there. He knows the property, he knows the owners, he's grown up with these folks, he passes by all the time, not once, not twice, 3 passes. There was no body on that lawn, period, at 2:30 a.m. And what other suspicious thing happened that night? By 3:30 a.m., someone moved a Ford Edge in front of the very area that would obstruct the view of where John's body would ultimately be discovered. Who's the only person in this case that you've heard about with a Ford Edge? Brian Albert. Remember, as you're thinking about this, the basement at 34 Fairview is serviced by a bulkhead. It's a quick and convenient door to the backyard. And that backyard is serviced by a side fence. And that side fence is easily accessible to the front yard at the side of the house. Which side of the house? The side where John's body was found. And by 6 a.m., John's body was, in fact, now outside. While this flurry of suspicious activity was going on with the Alberts and the McCabe's, what's happening with Karen? All she knows at this point, think about it, at approximately 2:21, she dropped off John, he walked into 34 Fairview, and that's all she knows. She knows nothing else that was going on. So what was she left to think? He goes in to check the party out, but all of a sudden he's not coming back. He's not responding. Minutes start to pass. 1 minute turns to 2, 2 turn to 10. Where is he? Why isn't he responding? She's sitting in the cold, dark, freezing outside in the car. Naturally, she's perturbed. Being perturbed turns into being peeved. Being peeved eventually turns into being pissed. By 12:30, Karen's mad. She's left 34 Fairview to make a point, but she's still texting and calling. What could she reasonably be thinking at this point? What's going through her mind? 12:33 turns into 12:34. I can't believe he'd do this to me. 12:34 turns into 12:35. Where is he? Why aren't you answering, John? 12:35 turns to 12:36. Jesus Christ. I'm calling and you're not answering. Where are you? Pick up the phone. But there's still no answer. There's still no response. By 12:37, she's getting furious. She does not know that something has happened to John. She does not know that. So she leaves the first angry voicemail. Illustrates frustration, aggravation, all the normal responses anybody might have, you and I might have. But little did she know. The next open voicemail has Karen parking at John's garage after she gets home. You can hear her heels clicking across the garage floor. For all she knows at this point, John's just drunk, he's been partying, he's hanging out, just forgot about her, blowing her off. But John's still not responding, and as the minutes tick by, Karen becomes increasingly upset. Those are the voicemails that you heard. How could he do this? Why is he ignoring me? Why is he ignoring the kids? Those are the thoughts bearing down on Karen Reed as she sat in an empty house late at night by herself. Ladies and gentlemen, she did not know what had happened to John. But within the next voicemail, you quickly learn what she was thinking and what she was feeling. Now it's 5:23 a.m. She's woken up, she's realized that he hasn't come home and he hasn't responded to a single text, not a single call. And anger quickly turns to panic and abject fear. She's so distraught, she reaches out to him again. John, where the fuck are you? She says through tears and desperation. And at 6:03, her question was answered and her worst fears were realized when she finds his body laying, dying in the cold in Brian Albert's front yard. You heard her, you can feel the grief, you can feel the raw anguish, you could see it. You don't have to wonder the emotional journey that Karen traveled that night. You can see it in the video. You can hear it in the audio. From the time he left her and walked into 34 Fairview and she called, she reached out 53 times. She called him 53 times before finding his body. Think about that. The Commonwealth wants you to believe that she murdered this man. And then after that murder, she called him not once, not twice, 53 times. It makes no sense. What does make sense is that she emotionally moved from anger, then to panic, then to grief. So back at 5:07, when she began her search looking for John, she backed out of the garage, and what would happen next would change the entire course of this case. As she backed out of that garage, she hit John's Traverse and cracked her right rear taillight. Folks, the Commonwealth has one job to do in this courtroom. It's an immutable responsibility to provide you with the truth. That's it. Not to win the case, but to seek justice and to do it through the truth. Ask yourself, did you get that truth from the Commonwealth? The Commonwealth continually tried to tell you that that video showed that the SUV came close to John's Traverse, And it took us showing you the video to unequivocally establish that Karen hit that car and cracked her taillight at 5:07. You can almost hear an audible gasp in the courtroom when we finally showed you the actual video. You can see that tire move. I'm only going to show you one series of exhibits during my entire closing, but it's that important. And it's this. Look at the condition of her taillight when she pulls out of the driveway at 5:07. That taillight, and I'm going to choose my words very carefully here. That taillight is cracked, but it's not completely damaged. And if there was any question in your mind about the level of damage to that taillight at 5:07, all doubt was extinguished when Dighton Police Officer Barrows walked into this courtroom. He's a sworn officer. He's not associated with Canton. He's not associated with the Alberts. He's not associated with the McCabe's. He doesn't know Michael Proctor. In other words, he doesn't answer to any of these folks. He's an outsider and he's completely independent. And his words were the following, quote, "That taillight was not completely damaged. It was cracked. A piece was missing, but not completely damaged." Take a look at this photograph and tell me, which one looks like Officer Barrows' description? The one on the left or the one on the right? The reconstructed light on the left is what that light looked like before it was in Trooper Proctor's possession. Remember that. That's what it looked like before Trooper Proctor had access to the SUV. And you have an independent police officer telling you so. You'll recall that after John's body was discovered, Lank, a very good friend of the Alberts, walked into Brian Albert's house and had an off-the-record meeting with him. No one's ever going to know exactly what that meeting was about, what they discussed, because that interview, like everything else in this case, it wasn't recorded. It wasn't memorialized. But we do know that shortly thereafter, the Canton Police Department was recused from the matter entirely. And the case was assigned to one Michael Proctor. You have to believe that when the Alberts found that out, they thought they hit the lottery. They thought they hit the lottery. What are the chances? The department where my brother works, that would have been great to investigate this case, but that department's been recused. That's tough luck. But the guy who catches the case is Michael Proctor, a guy we go back with for decades. At such a break, they probably thought, when this is over, we need to get that dude a gift. Oh, wait a minute. They didn't think that. They said it out loud. But still, you've got to imagine that the Alberts had to be stressed, what with that whole thing about a dead body being on their lawn. That might get some attention, and they had to be wondering, will he set up a crime scene? Is he going to come into the house? Is he going to search the house? Is he going to send in a forensics team? Is he going to interview witnesses? Is he going to take us to the station? Will he take our phones? Will he look at our communications? Will he look at our Google searches? Will he look at our early morning phone calls? Is he going to look in the basement? And Michael Proctor answered every single one of those questions resoundingly. Nope. He's a Boston cop too. And with that, Michael Proctor didn't draw a thin blue line. He erected a tall blue wall. A wall that you can't scale. A wall that Karen Reed certainly couldn't get over. A wall between us and them. A place you folks are not invited. We protect our own. It's us or it's them. And by the way, who's she after all? Nobody. An outsider. This is going to be easy. Or so they thought. Let's look at what Michael Proctor actually did and did not do in this case. One of the consistent issues that's come up throughout this trial is how evidence always seems to be changing and evolving when in Michael Proctor's hands or somebody in his orbit. If it happens once, let's chalk it up to a mistake. Twice, it's starting to look a little bit like incompetence. If that happens every single time, it becomes intentional, which means it becomes corruption. The defense spent some time, we spent some time discussing the tow time that Michael Proctor swore to in affidavits. There was a reason that we believed it was so important, and I want to talk about that for just a quick second. Because this was a concerted effort by Michael Proctor to falsify the time the car was seized, so that no one would know that he actually had possession of the car before the first pieces of taillight were ever discovered at the scene. But he got caught. And when he did, the best he could come up with was it was a typo. Like a dozen times, a typo. You'll remember what that testimony was. The truth is that car was in Michael Proctor's possession from about 4:12 in the afternoon. He said it was 4:16 when he finally had to tell the truth, or some version of the truth. Those first pieces of taillight were not found until after 5:45 p.m. That is the very fact that Michael Proctor was trying to hide by those falsified affidavits, saying he didn't seize the car until 5:30. But that wasn't Michael Proctor's only manipulation of the investigation. What about Brian Loughran? You met him. Michael Proctor did his level best to not just hide evidence, but to hide human beings from you and from us. Michael Proctor was informed that the plow drivers were out that night. There would be a witness, potentially along 34 Fairview, at the exact times in question. Even Michael Trotta expressly told Michael Proctor that 34 Fairview had in fact been plowed that morning, and by whom. Proctor not only did not interview Brian Loughran, he never disclosed his name in a single report. He hid him. This is a witness who was literally on 34 Fairview at the time in question where a body was found on the lawn. Wouldn't you want to get the truth from an eyewitness? Wouldn't you want to seek that out? Not if you're Michael Proctor, a close friend of the Alberts. If it were up to Proctor, you literally never would have heard of or from Brian Loughran. That's a scary prospect. I want to touch briefly on the additional physical evidence, or some additional physical evidence presented by the Commonwealth in this case. You'll recall Christina Hanley. She established to a scientific certainty that the glass on the bumper, which was told to you in opening statement, was going to have something to do with this case. The glass on the bumper was going to match that cocktail glass. She told you unequivocally the glass on the bumper did not match the cocktail glass. They came from two different sources. The glass on the bumper has nothing to do with the cocktail glass. So that glass on the bumper had to get there somehow. It didn't get there by being broken from the cocktail glass. See the point? It had to get on the bumper somehow. It didn't jump up there by itself. And what's really interesting is that there was one piece on the bumper, only one, that matched something else in the case. It was a perfect match to a piece of glass that was supposedly found at the scene. Who do you think had possession of that matching glass? Michael Proctor. So the glass on the bumper had to be placed there, and the only person who had anything close to matching the pieces that had to be placed there is Michael Proctor. You do the math. That leads us to the magic hair. The Commonwealth spent a lot of time bringing in experts about mitochondrial DNA and maternal DNA lines and comparative analyses, and all that sounds really great and really sciencey, except for the fact that it just doesn't matter. Why? Because you would have to believe that that little hair, tiny, tiny little hair, barely perched on the side of that SUV survived nearly 75 miles of a raging blizzard outside. That would be a magic hair indeed. That magic hair means nothing. The DNA means nothing, and that's because the hair was from somewhere else. It certainly was not from a motor vehicle incident at 34 Fairview on January 29th. That hair was placed there. The DNA on the outside of the taillight housing also merits very little discussion. John's DNA would be expected to be found all over that SUV, inside, outside, the exterior, the interior, everything he touched would have had his DNA on it. Here's what's actually important about that DNA. No DNA was found on the interior of that taillight, the taillight that they now claim crashed into his arm and shattered. No blood was found anywhere on that taillight or any taillight pieces, and no tissue was found anywhere on that taillight or any taillight pieces. but we're to believe that that taillight literally exploded on John's arm at 25 miles an hour with 1,000 pounds of pressure. We talked about the evidence doing very funny things when in Proctor's possession or the possession of somebody in his orbit. Now think about the videos that you saw. How many videos appear to be somehow manipulated or altered? Just about every single one of them. Look at the video of the sally port. Let's take that one, for example, that grainy one. It's missing the exact time that would show the condition of the taillight when it was pulled in to the sally port. Pretty important time, wouldn't you think? Did someone not want you to see what the condition of the taillight was at that exact time? But the good news is there's a second video. It's much clearer. And it's from the same time frame. We didn't get that one for about 2.5 years into the investigation. Literally, it was after the trial started that that one was turned over. And this is important. The Commonwealth introduced you to a person by the name of Yuri Buchanan. They presented video showing what was clearly the right side of the car. They asked questions about the right side of the car. You'll recall, Mr. Lally asked Sergeant Buchanan, did you or Trooper Proctor ever go at, or near the right side of that taillight? And while he was asking the question, what appeared to be the right side of the car was looking at you. The video was still up. Buchanan paused, turned earnestly into the microphone, stared at you and said, never. We never went anywhere around that taillight. While he was showing you the right side of the car. And that trick might have worked until we got up to cross-examine him. And only then, on the second day of his testimony, did he have to admit that the video was actually inverted. It was backward. And it was cleverly inverted at that. The timestamp had the proper orientation, which means that timestamp had to be removed, the video inverted, and the timestamp placed back on it. Which means that was done intentionally. That was not a mistake. And when caught in that obvious fabrication, Buchanan doubled down and said, it's exactly the same. You remember that back and forth. It's exactly the same, he said, as if we're stupid. Is it exactly the same, or is it exactly opposite? Ladies and gentlemen, you were lied to. There is no other way to say it. It's inexcusable. It's abhorrent. But it's also a paradigm of everything that the investigators have been willing to do in this case. Lie, obfuscate, manipulate, alter. And when they're caught, they just excuse it away. Doesn't matter. It's the same thing. What's the big deal? Just look the other way. And don't forget, Buchanan is Proctor's supervisor. And he was in that little group chat where Karen Reed's naked photos were being searched for. You know the saying about the apple falling from the tree. Ladies and gentlemen, we haven't even started talking about the taillight yet. You'll recall that at the very beginning of this case, you were introduced to no fewer than 5 CPD officers very early on who searched the scene. None of them, not a single one, found any taillight material at the scene. 0. Stephen Seraph, Sean Good, Stephen Mullaney, Michael Lank, Paul Gallagher, they were all there. They were all walking right around there. They were all looking. They were searching with their eyes. They were searching with their hands. Some said they were searching with their feet. They even used tools, a leaf blower. Not one piece of bright red taillight material was at the scene, not a single piece, but incredibly, over the course of the next 3 weeks, according to Michael Proctor, 47 pieces of taillight material would end up being found, some of which were the size of a salad plate. The CERT team shows up later on January 29th, and according to O'Hara, the first few pieces of taillight were found about 5:45. And here's some interesting testimony that you heard. Who else was there? Who did O'Hara say was there? Well, he said his team was there. We certainly expected that, but then he said there were others. These other mysterious figures, some from Canton PD, some from the Massachusetts State Police, that he could not account for. Heavy coats, big masks, hats. Even Lieutenant O'Hara could not tell who was who, but he did note Canton police officers were there who were unaccounted for. Massachusetts State troopers were there unaccounted for. And during that search that was overseen by Trooper Tully, Proctor's supervisor, 3 pieces of taillight material were found. That's super important, and I want to concentrate on that for a second. O'Hara said all 3 pieces were in an area about 12 inches square. That's an area about as big as your dinner plate. Tully, however, claimed that 1 red piece was found. About 3 feet away from that was a shoe. About 1 to 2 feet from that was a clear piece of plastic, and a few feet away from that was a red piece of plastic. So we have red, clear, and red over the span of about, added up, probably 10 or 12 feet. Ladies and gentlemen, both of those things cannot be true. Somebody is taking liberties with the facts. Then Lieutenant Tully comes to court and makes this big grand gesture of opening all these evidence bags. These 2 evidence bags in particular represent exactly what we're talking about, those 3 pieces, red, clear, red. They're marked, they're sealed, they look official. They're not Stop and Shop bags, thank God. At least they've moved up from that. They've even got evidence tape on them. Who knew? There's evidence tape around here. So this must be real evidence, right? It must be real evidence in this case. And after making that big theatrical display, he opens up the bag with the red pieces and he pulls 2 pieces out. That's okay. Put the 2 red pieces together. Good so far. Then he opens up the second bag under Mr. Lowley's questioning. And you remember, he hesitated just a second. Opened that bag and pulled out 1 piece of clear plastic. Then pulled out a second piece of clear plastic with no explanation as to how that could have possibly happened. And he quickly returned all 4 of those back into the bag, sealed them up, and we're done for the day. The next day, I asked about that evidence again. I asked him to open up that bag with the red pieces, and he did the same thing. Pulled out 2 red pieces of plastic. And I said, you'll recall this, I said, look deeper, look closer, sir. Pull everything out of that bag. Would he have had I not suggested it? And then he pulled a 3rd piece of red plastic out of the bag. So miraculously, Trooper Tully's 3 pieces of plastic became 5 pieces of plastic right before your eyes. Ladies and gentlemen, the forces at play that multiplied those pieces of plastic inside those evidence bags are the same forces at play that multiplied the pieces of plastic at 34 Fairview. Think about that. Let that sink in for a second. How easy is it? That's not sloppiness. That's evidence manipulation. That's how over the course of 3 weeks, those pieces of plastic go from 0 to 3 to 5 to 47. Ever increasing in size with every single search. Now, knowing all that, ask yourself the looming question, who had access to that taillight, the cracked taillight? Who was it? Go back and watch the Sally Port video. I'll give you the timestamp, 5:37. And see it for yourself. We know that Trooper Proctor, with binder in hand, walked by himself. Once we corrected the video from being inverted, you can see that he walked back by himself to the right rear taillight where nobody could see what he was doing. Higgins' own key swipes put him in the Sally Port that same afternoon and evening. And then the Sally Port video magically skips and Chief Berkowitz appears right next to Proctor at the back of that vehicle in the same spot, and they walk out of the Sally Port together. Where were they going? Remember O'Hara. Unidentified troopers in Canton cops were at the search at 34 Fairview. How hard is it to drop a piece of plastic? We spent a long time talking about the compromised and altered and tampered and manipulated evidence, and now I want to switch and talk a little bit about the true facts in this case, because you did hear some true evidence and true facts. The Commonwealth presented about 67, maybe more, witnesses and expended 30 plus days of trial and 9 weeks of your life. Maybe we're in the 10th week. For what? It should be relatively simple, right? The Commonwealth claims that Karen Reed pulled up to 34 Fairview, John got out of the car, she reversed into him and hit him, and then she drove home. That's 4 facts. It's just 4 facts, that's all it is. What evidence do they actually have to prove that that SUV ever hit John? The answer is none. They don't have any. There's no evidence whatsoever that Karen Reed's vehicle ever struck John O'Keefe or that Karen Reed ever wanted to strike John O'Keefe. In fact, every single piece of material evidence in this case unequivocally proves the opposite. John went into that house. That SUV was not damaged by hitting John, and John's injuries did not come from being hit by a car. That's what the evidence actually shows. The Commonwealth knows that, and they've known it for a long time, and Proctor knows that. And because of that, the Commonwealth just resorts to character assassination and talking for weeks on end about the snow. Let's talk about what the real evidence actually shows, the unassailable science. Let's talk about the truth. Concerning John's injuries first, the Commonwealth's own medical examiner, Dr. Scortibello, could not conclude that John was hit by a car. Think about that. And she would not even say that it was a homicide. She told you without any dispute in this case, quote, evidence pointing toward one manner of death is no more compelling than evidence of a competing manner of death, end quote. Her words, not mine. She went on to say it's just as likely that he was punched and fell backward. His injuries are consistent with that. In fact, in her expert opinion, his injuries are consistent with a physical altercation, as she testified, but they are not, in her words, not classical injuries from an auto-pedestrian accident. That by itself is reasonable doubt. But the evidence and the truth goes far further. We introduced you to not one, but two thoroughly credentialed medical examiners, or medical experts, Dr. Sheridan and Dr. Russell, both of whom said John's arm injury is consistent with an animal attack. Dr. Russell studied, diagnosed, and treated up to 1,000 animal wounds. She's an expert in animal wounds, and she was unequivocal. Those wounds are from an animal, likely a large dog, which means that John was attacked inside the home where Chloe was. There is no other possibility. And Dr. Sheridan, for his part, with thousands of 13,000 autopsies under his belt, decades of experience as the chief medical examiner who's triple credentialed in anatomical, forensic, and neuropathology, he told you that John's injuries are inconsistent with a motor vehicle accident or incident. They're consistent, however, with a physical altercation. In layman's terms, the science proves John was beaten. That also is reasonable doubt and should end this case. But the facts and evidence don't stop there. Two of the most highly educated and highly qualified engineers you'll ever meet, Dr. Dan Wolf and Dr. Andrew Rinchler, mechanical engineer and a biomechanist. They reviewed this case. They did testing, they did analysis, they evaluated the case scientifically. They were not hired by the defense, not by the Commonwealth. They're completely 100% independent of any party in this case. And they were equally available, by the way, to the Commonwealth. They could have called them. They explained that John's injuries were not caused by being hit by Miss Reed's SUV, and that the SUV was not damaged by coming in contact with John O'Keefe's body. That should end the inquiry right there. Both sides of the equation. From a physics, engineering, and biomechanical standpoint, they established that John O'Keefe was not struck by Karen Reed's vehicle, period. And that is yet another fact that establishes reasonable doubt and should put an end to this case. So instead of calling the ARCA experts, which they had available to them, the Commonwealth chose to introduce you to Trooper Joe Paul. You'll remember his testimony. I think I'm being kind when I say that Trooper Paul's analysis lacked credibility. Trooper Paul lacks the experience, the education, the training, the background, and the knowledge to not only render opinions on these issues, but to even understand the issues themselves. He makes the absurd claim that John was hit on the elbow area of his arm by a taillight. He was spun to the left in a pirouette. His arm stayed on the light long enough for the shards of plastic to explode around him, scratching his arm even though he was wearing long sleeves, then projecting him 30 feet to the left, but not before making a stop to hit his head on either the curb or the pavement before coming to his final resting place with his unbroken phone tucked neatly under his body. It's nonsensical. It borders on laughable. Compare that testimony to Dr. Dan Wolf and Dr. Andrew Rinchler. Both PhDs in engineering, both top of their field in accident reconstruction, both published peer-reviewed articles on the issues. Both men are highly sought after by the likes of national sports leagues and the United States Department of Defense, and these men are unrivaled in accident reconstruction. What did Dr. Rinchler say before he left the stand? This was even under cross-examination. He said that the physics and the science don't lie. His words were, you can't deny the science and the physics. John wasn't hit by that car, period. The Commonwealth cannot explain John O'Keefe's injuries. They can't explain his head wound. How did he get the head wound if he landed on snow-covered grass and dirt? And by the way, before Mr. Lally gets up and says it, because I know he's going to, there is zero evidence before you, zero, that cold grass and dirt turns into ice or turns into concrete. Zero. They can't explain the injury above his right eye, that laceration. They can't explain his nose. They haven't even tried to. They can't explain the injury to his tongue, the laceration on his tongue. They cannot explain the injuries to the back of his hands, the bruises, and certainly they cannot explain the injuries to his right arm. But maybe most importantly, they cannot and haven't even tried to explain the lack of injuries on John's body from the neck down. Nothing. He was pristine. Not a bump, not a bruise, not a fracture, not a broken bone. Nothing to suggest that he was hit by a 7,000-pound SUV going 25 miles per hour. And what of that right arm? According to the Commonwealth's best and brightest, Trooper Paul, John absorbed the entirety of the collision, the whole collision, with that 3.5-ton SUV entirely with his right arm, launching him some 30 feet. But amazingly, the arm suffered no break, no fracture, and didn't even get a bruise. So how are those injuries properly explained? The evidence is simple. John got into an altercation. He was punched. He tried to defend himself by putting his hands up. He may have even scratched his own nose by putting his hands in front of his face to defend himself. His hands were bruised and covering up.
Five minutes, Mr. Jackson.
Thank you, Your Honor. As he continued, he got hit, a punch went through, and he fell to the ground, fracturing his skull. At some point during that altercation, the dog got a hold of him, and the dog was pulled away. Every single injury is answered. Every single injury is explained by that. Ladies and gentlemen, given what we know about the facts and the physical evidence in this case, the actual truth in this case, how did this happen? How did we end up here? We ended up here because of relationships, insider trading, playing the who you know game, and building a tall blue wall, which takes decades and generations. But the real question is it going to continue? Will this festering malignancy that allows a lead detective and his supervisor to gloat and sneer while looking over naked pictures or looking for naked pictures of the woman that they've targeted, will that continue? And the answer should be, not if you have anything to say about it. Michael Proctor is the lead investigator in this case, and much as the Commonwealth might try, they cannot distance themselves from the stench of him on this case and this investigation. Those secret group chats illustrate the quality and character of his investigation. Remind yourself how an, quote, unbiased and an objective investigator, someone who's supposed to be looking for facts. Ask yourself, how did he approach his job? Late at night, sitting there in his office, deviously looking for naked pictures of Karen Read and talking about her like she's a piece of meat. Talking about her bodily functions, her medical conditions, calling her vile names. I don't even have it in me to repeat what he said about her. He reduced her to an object. And he went further by insulting her. He went further than insulting her, and he dehumanized her. And when he was done betraying that very humanity, he wished for her to commit suicide. That, ladies and gentlemen, is how you frame someone. That's how you dehumanize someone so viciously that you can just pin it on the girl and cover for the homeowner because he's a Boston cop. That's how you rip a person's life apart and sleep like a baby while doing it. And then further that by saying, I hope she kills herself. Ladies and gentlemen, I just began the discussion this afternoon or this morning with a quote about the truth, and I did that because that's what this case is about. Top to bottom, tip to tail, it's about the truth. Not hiding it or concealing it, but exposing the truth. The truth is immutable. It's not a feeling, it's not a whim. It's unflinching, it's unchanging, and it's everlasting. That's why the law is steady. That's why it's not captive to the whims of people drunk with power who think they're above the law, who think they're above scrutiny. That's why you stand as the guardian of justice and the protector of justice. The law demands the very integrity that Trooper Proctor and his investigation lacks, and it requires that you cannot convict Karen Read unless the Commonwealth has met its incredibly high burden to prove every element beyond a reasonable doubt and to a moral certainty. And a moral certainty is defined as the highest degree of certainty possible in matters related to human affairs. It's the highest degree possible in your life. That's the level of certainty. And I'll leave you with this. You have the most powerful tool known to American jurisprudence because you have your vote. No one can take that away from you, not me, not the Commonwealth, not the court. You may not have asked to be here, but each of you have given something very special of yourselves. You've agreed to do that which is the highest calling a citizen can answer in any way. You've agreed to give your community your best. And my question to you is, what will you do with this moment? Ignore the lies, the manipulations, the misogyny, the bias, the lack of evidence? Could you ever do that? Would you ever do that? Or will you say with your verdict, I see the truth, and I will not ever look the other way? When you stare the truth down, you'll see that the Commonwealth has not proven its case beyond a reasonable doubt and to a moral certainty, not even close. Ladies and gentlemen, Karen Read is innocent. Do justice and find her not guilty. Thank you.
All right. Thank you very much, Mr. Jackson. All right, Mr. Lally.
Thank you, Your Honor. I hit him, I hit him, I hit him, I hit him. Those are the words of the defendant. 4 times. You heard testimony from 4 different witnesses who overheard and observed those statements from the defendant on January 29th, 2022. You heard testimony from firefighter Timothy Nuttall. He was trying to bag, valve mask Mr. O'Keefe. He was working on resuscitative efforts to try to save Mr. O'Keefe's life. He asked if anyone saw anything or knew what happened, and the defendant said, I hit him, I hit him, I hit him, I hit him. Firefighter Anthony Flamati was asking if anyone had information on why Mr. O'Keefe was there in the snow. The defendant repeatedly said, I hit him, I hit him, oh my God, I hit him. Firefighter Katie McLaughlin was tasked by firefighter Flamati with asking for biographical information and for what the cause was of the traumatic injuries that all the firefighters testified that they observed on Mr. O'Keefe. She asked the defendant, and the defendant said, I hit him, repeatedly. Firefighter McLaughlin asked for clarification. You did what? And the defendant repeated, I hit him. Jennifer McCabe stated initially over the phone when speaking with the defendant that the defendant said, could I have hit him in the car while they're on the phone with Ms. Roberts going from Ms. McCabe's house to Mr. O'Keefe's house? Did I hit him? Could I have hit him? Once on scene, once asked, as Ms. McCabe described by an EMT, for name, age, things like that related to Mr. O'Keefe, what caused the trauma? She indicated in her testimony that the defendant said repeatedly, I hit him. You heard testimony from Officer Sarif, statements that he attributed to the defendant as saying that morning, this is all my fault. This is all my fault. I did this. This is what the defendant is saying on scene. Since then, the story's changed a little bit. But those were the words that came from the defendant's mouth on January 29th, 2022, as John O'Keefe lay dying on the front lawn of 34 Fairview Road, where the defendant had left him after striking him with her motor vehicle several hours before, and then left him freezing there in a blizzard. There's certain things that have come up over the course of this trial as far as evidence and testimony are concerned, little things. And what I would suggest to you, it's those little things that are quite telling as it pertains to the defendant's statements and the defendant's actions over the course of January 28th and January 29th and beyond. And I'm going to bring some of those to your attention as I go through, but just ask you to keep that in mind as far as when you're deliberating, when you're reviewing this testimony and this evidence. The little things matter. The little things start piling up in this case. Throughout the course of this trial, you've heard a lot of purported evidence or questions of witnesses in an attempt to distract you from the evidence in this case. It's essentially defense by obfuscation. It's a three-card money trick. The facts and the evidence in this case are your card, they're the Queen of Hearts. And so what I want you to, or what the defense wants you to do is not look at that card. Look at anything else. Look at the movement, look at this person, look at that person, look at text messages, look at this. Don't pay attention to the facts and the evidence, because if you do, what it will ineluctably lead you to is that the defendant is guilty of each of the three indictments before this court. The evidence and the facts of this case are for you, the jury, to decide. Using your common sense, using your life experiences as your guide through that as you go. Before I turn to that evidence that I will submit to you ineluctably demonstrates the defendant's guilt, let me first just address Trooper Proctor. The text messages from Trooper Proctor are unprofessional, they're indefensible, they're inexcusable. However, as distasteful as those messages are, and their content is, I submit they had no bearing whatsoever or impact whatsoever on the integrity of the entirety of the investigation that Massachusetts State Police collectively conducted into John O'Keefe's death here. As was asked of Trooper Proctor on cross-examination, these were texts from his personal phone that he never thought would see the light of day. He was asked whether or not he ever thought that he would be asked about these in a courtroom, put to him in sort of a safe space, a safe place for him to discuss, if you will. What do you not see in those text messages? You don't see any discussion or any illusion of any conspiracy, of any framing of the defendant, of any planting of any evidence, no evidence whatsoever. Why? Because it didn't happen. There is no conspiracy, there is no cover-up, there is no evidence of any of that beyond speculation, rampant speculation and conjecture on behalf of the defense. Two things can be true at the same time. They're mutually exclusive. The texts from Trooper Proctor are distasteful, they're disrespectful, they're unprofessional, there's no defense to them. And the defendant killed John O'Keefe. Turning to the evidence, let me first talk a little bit about John O'Keefe. You heard a lot about him over the course of this trial, about his selfless story through his family and friends that loved him, including his adopted niece and nephew. You heard a lot about the lives he touched and the different people who he had friendships with. You heard a lot about from those particular friends and from his family. Turning to what I would submit to you as a timeline. This may be a little hard to see up here. What I'm going to go is from left to right. January 28th, 2022, 9:49 in the morning, Karen and John begin fighting over text messages. 2:25 p.m. in the afternoon, the defendant texts Mr. O'Keefe, "Tell me if you are interested in someone else. Can't think of any other reason you've been like this." John texts back, "Nope." 2:25, Mr. O'Keefe texts the defendant, "Things haven't been great between us for a while. Ever consider that?" This is also testimony that you heard through multiple sources, whether it be phones, whether it be from the children, whether it be from other friends or family members as to the relationship in the months and weeks leading up to John's murder. 2:32 p.m. John texts the defendant, sick of always arguing and fighting. It's been weekly for several months now. He then texts the defendant, OMG, stop calling. This is during the time frame that Trooper Garino was talking about, with 18 phone calls, most of which were rejected, some of which were missed, and a couple of which were answered over the course of this afternoon, as she's continuing to needle and try to engage him in a fight that he doesn't want to have. 2:33 p.m., the defendant texts John, so you're not into this anymore. 2:34 p.m., John texts the defendant, I am not answering, stop calling. The defendant then texts John, then stop starting with me. 2:38 p.m., the defendant texts John, I'm going to grab a drink in a bit. At 2:38 in the afternoon. Around 3 p.m. is the testimony you heard from Erin O'Keefe in regard to the defendant texting her, asking if she can go out without her husband, Paul. Asking to go out for a drink. This is while Erin O'Keefe testified she was waiting for one of her children at the bus stop, picking that child up around 3 o'clock in the afternoon. This is also the point in which the defendant says to Ms. O'Keefe, wish I didn't speak to another O'Keefe after 2004. 7:30 p.m., you have Mr. O'Keefe and Mr. Camerano arriving at C.F. McCarthy's, with the defendant arriving at 8:51. 8:58 p.m. is when the defendant receives drink number 1 at C.F. McCarthy's. Vodka soda, tall cylinder glass, lime, and a straw. 9:13 p.m., drink number 2. 9:20 p.m., drink number 3. 9:33 p.m., drink number 4. 9:57 p.m., drink number 5. 10:22 p.m., drink number 6. 10:29 p.m., drink number 7. 7 drinks from 8:58 p.m. through 10:29 p.m. when she receives that last drink at C.F. McCarthy's. The drink that she indicates to Sergeant Mechanic and several others on the next day that she did not take with her from C.F. McCarthy's to the waterfall, which several individuals at the waterfall testify that she produced from her coat when she walked in, and that you can clearly see on the C.F. McCarthy's video her walking out the door with the same tall cylinder glass in her right hand. Now, understanding that some of these drinks are not the full tall cylinder drinks, what she's doing is she's getting shot glasses of vodka and then pouring them into the drink after she's consumed the drink. 10:54 p.m., the defendant and Mr. O'Keefe arrive at the waterfall, during the course of which, on an hour that they're there, the defendant receives drinks number 8 and drinks number 9. 12:10 a.m., from the waterfall video, you have Ms. McCabe, Ms. Kolokithis, and the defendant departing the waterfall together. Interestingly, around the same time, you also have the text and screenshot communications between Colin Albert and Allison McCabe in reference to him getting picked up at that time. You also have testimony from Brian Albert, Nicole Albert, Caitlin Albert, Brian Albert Jr. in reference to them sort of walking in from the waterfall as Colin Albert is walking out of 34 Fairview Road, gets picked up by Ms. McCabe, and then is driven home. 1 minute later, 12:11, Mr. O'Keefe is then on the waterfall video walking out with cocktail glass in his right hand. At 12:14 a.m., Mr. O'Keefe texts Ms. McCabe, where to? 12:14 a.m., based on the fact that she's driving, and Matt McCabe indicated in his testimony that she should call him instead of texting while driving, Ms. McCabe calls John O'Keefe and speaks with him regarding directions, sort of going over which way to come in Chapman Street, over Cedar Crest, as far as coming into Fairview Road. 12:15:38 a.m., the defendant's vehicle drives by the Canton Library. You can see that on the video. 12:17:56, the defendant drives by the Temple Beth Abraham video. Again, you can see that on the video. Remember also the testimony from Lieutenant Tully in regard to the CSLI data and the ranging data in reference to it coinciding with what you observed, the black SUV, from each of those respective videos. 12:19:32, Mr. O'Keefe enters 34 Fairview Road into his Waze app on his phone. 12:23 a.m. is when the defendant conducts a 3-point turn on Cedar Crest and travels back toward Fairview. That's from Mr. O'Keefe's GPS native location data from his phone. Around the same time at 12:23 and 12:24 is when you have that testimony from Ryan Nagel, Heather Maxson, and Ricky D'Antono pulling into Fairview Road around the same time and pulling in behind the dark SUV. 12:25 a.m. is the last native location GPS data of John O'Keefe's phone. It's in that area between 32 and 34 Fairview Road, where his body is discovered the next morning, in which there is no movement of that phone from that 12:25 a.m. period until Miss Roberts then picks up the phone on the grass underneath Mr. O'Keefe's body sometime after 6 a.m. What you have up on the screen right now is that data, those plotting points that Trooper Garino was testifying about as far as the movement of the vehicle. The movement of the vehicle as it comes down Cedar Crest, passes by Fairview, reverses direction, and then comes down Fairview, moving up, moving up, moving up, as the witnesses described, eventually stopping in that area of the property line between 32 and 34 Fairview Road, which happens to coincide with the vehicle control history database information from the Toyota text stream, which you now have up on the screen before you here, indicating that following that three-point turn, approximately 8 minutes after that, from Trooper Paul's testimony, as far as the mileage, 36 to 38 miles, matching up with the time that the vehicle is in front of 34 Fairview Road, that the vehicle travels in reverse, in a straight line, for 24.2 miles per hour for 62.5 feet, with a minor steering angle change, which the trooper indicated was consistent with a pedestrian collision. At 12:30 a.m., you have that second triggering event 8 minutes after the three-point turn when the vehicle is in reverse at 24.2 miles an hour. 12:35 is when the defendant calls John, and that's unanswered. 12:36 is around the time that the defendant's phone connects to the Wi-Fi at 1 Meadows Ave, Mr. O'Keefe's home. 12:37 is when the defendant leaves this voicemail. So within minutes of that vehicle's data, going 24.2 miles an hour in reverse for 62.5 feet, the defendant leaves that voicemail, seething in rage as she's screaming, "John, I fucking hate you." 12:40 to 12:42, Ms. McCabe is texting Mr. O'Keefe. She tries calling Mr. O'Keefe, gets no answer. If you recall from her testimony around this time frame, about 12:40, she was unsure whether the vehicle was actually still out front or if it had gone at that point. But she was looking for John because she had seen the defendant's vehicle in front of the house and no one had come in. So she was wondering where her friend, Mr. O'Keefe, was. 12:55, the defendant texts John, "See you later." 12:59, the defendant calls, leaves another voicemail for Mr. O'Keefe. Exhibit 637, it sounded like this.
"John, I'm here with your fucking kids. Nobody knows what the fuck you are, you fucking pervert."
But somebody did know where Mr. O'Keefe was. The defendant knew exactly where he was. She had driven him there, she had struck him there, she had left him to die there. 1:02 a.m., the defendant leaves another voicemail with no content. And then she texts John, "Your kids are fucking alone." 1:09 a.m., the defendant texts John, "I'm back in Mansfield. The kids are home alone." She's not. GPS, as far as it never disconnects from the Wi-Fi until the following morning. There's no indication that Ms. Reed left and went to her home in Mansfield at any point in time. 1:10 a.m., the defendant calls her parents. 1:11 a.m., she calls Mr. O'Keefe and leaves this voicemail.
"John, I'm going home. I cannot babysit Amy. I need to go home. You are fucking using me right now. You're fucking another girl. Kim's sleeping next to me. You're a fucking loser. Fuck yourself."
1:18 a.m., the defendant leaves another voicemail. Now, about 1:43 or 1:45 a.m. is when Julie Nagel testified that they were leaving the house. And she sees a large black object on the lawn near the flagpole while leaving 34 Fairview Road. Doesn't think much of it at the time, isn't expecting Mr. O'Keefe or any body to be out on the front lawn. 4:42 a.m., the defendant calls and speaks. The calls to her parents are finally answered. 4:49 a.m., the defendant calls Ms. Camerano, screaming, "Where's Mike?" 4:53 in the morning is when the defendant instructs Kaylee, Mr. O'Keefe's niece, to call Ms. McCabe. Why? Because the defendant doesn't have Ms. McCabe's phone number. Indicates that John didn't come home. We got in a fight, and I left him at the waterfall. Those are the first statements or the first version of events that she's able to communicate out to the world as to what happened to Mr. O'Keefe and where he is. We got into a fight. I left him at the waterfall. 5 a.m., the defendant calls Kerry Roberts, saying, "John's dead, Kerry, hangs up the phone. 5:01, the defendant calls Kerry Roberts again. And it's at this point that she indicates that John's dead, he must have been hit by a plow. 5:07 a.m., the defendant leaves One Meadows Ave. You have the video of that. It's number 153 in Exhibit 6. We'll get to that a little more in a moment. About 5:10 a.m., the defendant calls Kerry Roberts. Ms. Roberts starts calling hospitals, calling KPD, calling 911. Something that you would do if you didn't know where Mr. O'Keefe was for all of these hours, that all of these other phone calls are being made and these text messages are being sent and calling your parents and all of these other things. No calls to 911 from the defendant. While John O'Keefe is laying, freezing, and dying from a brain injury and a skull fracture on the front lawn of 34 Fairview Road. 5:11 a.m., the defendant's vehicle is seen on the Canton Library camera heading towards the waterfall. Seems to be sort of retracing the steps. 5:18 a.m., the defendant's vehicle is seen at Washington Street and Chapman on the Temple Beth Abraham video, heading in the same direction that it was the night before when it was heading to 34 Fairview Road. 5:35 is when the defendant arrives at Ms. McCabe's house. Ms. Roberts arrives shortly thereafter. Both of them see the broken taillight at that time in the driveway. Now that gap of 5:18 to 5:35 is way too much time to be driving from the area of the waterfall to Jennifer McCabe's house. And as I indicated a moment before, heading in the same direction, same directionality, retracing the steps from the night before, heading towards 34 Fairview Road. Why is it that the defendant can see Mr. O'Keefe when they eventually get to Fairview Road and no one else can? It's because she knew exactly where he was. She had hit him and left him there the night before, and she had gone back during that time frame between 5:18 a.m. when she's seen on the Temple video and 5:35 when she arrives at Ms. McCabe's house. 5:33 is when the defendant, Ms. McCabe, and Ms. Roberts return to One Meadows Ave searching for John. 6:03 is when the defendant, and no one else, spots Mr. O'Keefe's body buried in the snow. Exhibit 12, indicating this cruiser camera video, which I know you've seen a dozen times. So where I'm starting it from this point in this card right here is the spotlight that Officer Saraf had to use in order to locate, even with the vehicle of Ms. Roberts parked right in the middle of the road. In the darkness, in the snow, in the blizzard, in those conditions, the defendant, sitting in the back seat of the vehicle, knows exactly where Mr. O'Keefe is, covered in snow, as you heard from all of the paramedics, from the civilian witnesses, from the first responders. But the defendant knows exactly where he is. 6:07 a.m., Ms. McCabe calls 911. 6:08, the defendant leaves that 4 or 5 minute voicemail, leaving the phone in the car for some reason to Mr. O'Keefe's phone. 6:23 and 6:24 in the morning is when Ms. McCabe conducts those Google searches. 7:50 in the morning is when Mr. O'Keefe is pronounced deceased at Good Samaritan Hospital. 4:13 to 4:20 p.m. is when the defendant's SUV is towed from her parents' house in Dighton. 5:20 p.m. is when the search team arrives in the area of 34 Fairview Road to conduct the search for evidence. 5:30 p.m. is when the defendant's vehicle arrives at the Canton Police Department South. We circle back for a moment to Mr. O'Keefe, to his families, to his friends, and to his relationship with the defendant. You heard testimony from Paul and Aaron O'Keefe that they liked the defendant, that they thought he was good for John, thought he was good for the kids. All outward appearances of the relationship were good. You heard testimony from the children that that was not true behind closed doors. But Paul O'Keefe testified that he told the defendant's parents this, that he liked Miss Reed, that he thought that she was good for John, thought that she was good for the kids, weeks before John's murder. He even blew her a kiss in the emergency department at Good Samaritan as he was walking out and she was still being treated while they were there. Invited her over to John's house to grieve with him. Invited her to sit down with him while he explained to their nephew Patrick about John's passing. The defendant shows up at the house, abruptly goes upstairs with her father for a period of about 15 minutes, which is about half of the time that she spent there that morning grieving with the family. She left with a bag of her belongings, drove with her family there, and then took an extra vehicle in the height of the blizzard now, around 1 o'clock in the afternoon, drives that vehicle all the way from Canton, where it was parked at her boyfriend's house, where she stayed over on many occasions, drove that vehicle or felt the need to drive that vehicle from Canton all the way down to her parents' house in Dighton at the height of the blizzard. You heard testimony from Aaron O'Keefe of the text messages and the phone call on January 28th. You've heard that Aaron O'Keefe called the defendant on the morning of the 29th because she was concerned for her. She wanted to know what was going on with someone she considered her friend. The defendant yells, "John is dead." Ms. Robertson grabs the phone and then updates Aaron O'Keefe as to what's going on with John. Aaron O'Keefe again calls back later because she's concerned for someone that she considered her friend. How does the defendant respond? These are some of the little things. The defendant indicates to Ms. O'Keefe that she just has to remember the bad times and indicates to her, "I don't think I'll ever see you guys again." This is after she's done her quick in and out at One Meadows Ave and is now with her parents or with her father, driving that car, essentially taking the murder weapon from Canton and bringing it down to her parents' house in Dighton. She's indicating over the phone to Aaron O'Keefe, "I don't think I'll ever see you guys again." Why? If she didn't kill John, why would she say that? You heard a lot of testimony about New Year's Eve in Aruba. You heard the testimony from Ms. O'Keefe in regard to them exchanging, her and the defendant exchanging text messages on the flight down, arranging times to meet up. And then the defendant telling Aaron via text message that she caught Johnny kissing Laura's sister in the hotel lobby. She got into an argument about it, and then they never met up. Meaning the defendant, Mr. O'Keefe, got into an argument about it, and she and Aaron O'Keefe never ended up meeting up in Aruba. You heard testimony consistent from Laura Sullivan, Marietta Sullivan, as well as the children. The kiss never happened. It never would happen based on the relationship, the godfather relationship that John O'Keefe had with Laura Sullivan, her family, and particularly Laura Sullivan's child. The defendant persists with this unfounded suspicion and accusations of infidelity in her text messages with Mr. O'Keefe, in her text messages with Mr. Higgins, where she's accusing Mr. O'Keefe of making out in the lobby with Marietta Sullivan. Both of the Sullivans and the children have the defendant and Mr. O'Keefe following this incident with Marietta Sullivan going into a room. Both of the children testified that they're in that room for about 20 to 25 minutes and they're arguing about the defendant indicating that Mr. O'Keefe kissed someone in the lobby. And you have Laura Sullivan's testimony about 20 to 25 minutes after her sister comes out and states her displeasure about the defendant. It's about 20 to 25 minutes before Mr. O'Keefe comes out, and then he and Ms. Sullivan have a conversation. Ms. Sullivan indicates that Mr. O'Keefe's phone is essentially blowing up, lighting up with calls and texts from the defendant. I would submit similar to the afternoon of January 28th. Mr. O'Keefe says she's crazy and he needs to take this and goes off from there. Ms. Sullivan has later conversations with Mr. O'Keefe on this Aruba trip, asks him if he's okay, asks him if he's happy. She indicated in her testimony that Mr. O'Keefe shrugs it off and says it is what it is. You heard testimony from the children about the arguments in the weeks and the months. And I know this is a displeasure to the defense counsel that the children came in and actually testified as to what happened behind closed doors in the house. They both recall frequent fights. They both recall Mr. O'Keefe trying multiple times to break up with the defendant, asking her to leave the house, the defendant refusing to leave the house. His niece Kaylee, John tried to defuse, he tried to walk away, and the defendant would follow each time during each argument. They both indicated that Mr. O'Keefe had told the defendant that the relationship had run its course, similar to language within the text messages you have between the defendant and Mr. O'Keefe. That Mr. O'Keefe was sick of arguing, again, mirroring those text messages from January 28th, leading up into going out to C.F. McCarthy's, eventually the waterfall, and the defendant killing Mr. O'Keefe in the early morning hours of January 29th. We have the testimony in regard to the ring camera. Kaylee indicated in her testimony that John had had that for about a year. So during the course of the 2 years or so of the relationship with the defendant, he got it while he was dating the defendant. The defendant had the security code to the garage. Neither of the kids had access to the camera. Trooper Garino checked the laptop and the desktop that were left after the defendant did the quick cleanup upstairs with her father, upstairs in the home. Neither of those devices had access to the ring cameras. John had access on his phone. The defendant indicates, if you recall, in some of those text messages in regard to the romantic kiss that she placed on Mr. Higgins earlier on January, whatever it was, during the Patriots game. Mr. Higgins, who Mr. Jackson was indicating weren't very good friends with Mr. O'Keefe, but had been invited over to his home for a Patriots game, in which time the defendant escorted Mr. Higgins out of the garage and placed a romantic kiss on him. But during those text messages, when they're talking about that, if you recall, the defendant is saying something or joking about something that Mr. O'Keefe had been looking at the videos and had been asking her if there was something going on with her and Mr. Higgins. And what was her response to that? I know where the cameras are. There are only 2 videos missing from that ring system. One being the defendant getting to Mr. O'Keefe's house after murdering him, and the other when the defendant is showing Ms. McCabe and Ms. Roberts the broken taillight, both of which, both Ms. McCabe and Ms. Roberts testified as having occurred. No video of it. The variety of stories that the defendant tells on the morning of January 29th. There were text messages and voicemails from the defendant to Mr. O'Keefe, 53 phone calls from 12:33 a.m. to 6:03 a.m. 0 phone calls to 911. The defendant calls Katie Camerano. The defendant calls her parents at 1:18 in the morning, 4:38 in the morning, 4:42 in the morning. The call then from Kaylee's phone to Ms. McCabe, because the defendant didn't have Ms. McCabe's phone number. Both Kaylee and Ms. McCabe indicate that the defendant initially indicates or says that she got into a fight with Mr. O'Keefe and left him at the waterfall. From this information, Ms. McCabe then testifies she starts to call her Julie Albert, because Chris Albert, Julie Albert, they live close by the waterfall. Maybe that's where he went. As the phone is ringing, and this is a phone call that both Ms. Albert and Ms. McCabe testify was never answered. As the phone is ringing, her husband Matthew McCabe reminds her that they saw the defendant and Mr. O'Keefe and the car outside of 34 Fairview, so she hangs up. During this call, or during these subsequent calls, the defendant indicates to Ms. McCabe, maybe I hit him, did I hit him? She then calls Ms. Roberts at 5 a.m. on the dot, indicates John's dead, hangs up the phone, calls back a minute later, indicates that Mr. O'Keefe was now hit by a plow and that he's dead, and then indicates further that she's drunk and doesn't remember. She tells Miss McCabe about the cracked taillight before they even get in the vehicle and go anywhere, as you recall the testimony of Matthew McCabe, indicating that he had some concerns about them driving around in a vehicle with a damaged taillight in the middle of a blizzard. Ms. Roberts' testimony that she saw the broken taillight in the driveway at Ms. McCabe's house, and that it was consistent with what she observed in the photographs that were shown to her of it later in the Sally Port at the Canton Police Department garage when the search warrant is executed on February 1st. You have the text messages between the defendant and Laura Sullivan from January 29th, in which the defendant indicates to Laura Sullivan that John is dead, indicates that we found him in the snow at 5 a.m. And every indication is that he was found in the snow by the defendant, Ms. McCabe, and Ms. Roberts around 6 a.m. 5 a.m. would be about an hour before. 5 a.m. would be between that time where the defendant is unaccounted for, heading in the direction of 34 Fairview Road, 5:18 and 5:35. Little things. The defendant asked Ms. McCabe to Google how long to die in the cold. She did so at 6:23 and 6:24 in the morning. You have the testimony of Ms. Hyde and Mr. Whitford as to SQLite databases, P-list databases, Knowledge C databases, state DB tabs, as far as all of that. Also from Trooper Garino as well. These searches were unequivocally done at 6:23 and 6:24 in the morning, and not at 2:27 and 40 seconds in the morning. They were not deleted by a user. That is not what deleted means. Frankly, Mr. Green, the last question that I asked Mr. Green is, was he aware that Sellbright, and by Sellbright, the person who designed that being Mr. Whiffen, had to alter exactly how their software worked because of people like Mr. Green misinterpreting the data as he did in this case. And what did Mr. Green say? Yes. But those questions, as far as how long to die in the cold, I would submit mirror the questions that the defendant asked Firefighter Whitley in the back of the ambulance, if you recall those. She asked Firefighter Whitley how long to die in the cold without a jacket. She knew how Mr. O'Keefe was dressed. She knew when she left him to die in the cold how he was dressed. The defendant made statements to Firefighter Becker that the last time that she saw Mr. O'Keefe, they were in an argument. Again, in the back of the same ambulance as Firefighter Whitley. You have testimony from Firefighter Woodbury. Same kind of questions. If Mr. O'Keefe could be alive without a jacket. You have the testimony from each of these firefighters as to sort of the vacillating emotional state of the defendant that morning. What you have in the testimony from Firefighter Woodbury is that despite all that, there were no tears that he observed from the defendant at that time. What each of those first responders indicated is that the defendant repeatedly stated, is he dead? Is he dead? Not is he okay? Is he going to be okay? How is he? Any sort of questions about the medical condition. Is he dead? That phraseology repeated over and over and over again. And when you take into juxtaposition that phraseology, text to Laura Sullivan, found him in the snow at 5 a.m. The unaccounted for time heading in the direction of 34 Fairview Road, 5:18 to 5:35. The repeated questioning of Firefighter Whitley, Firefighter Woodbury, asking Ms. McCabe to look up those things in her phone. She's looking for confirmation, is what she's looking for when she asks over and over again, is he dead? Is he dead? Is he dead? You have the testimony that you heard from Ms. McCabe and Ms. Roberts. I say them together because as far as these two women were concerned, they did not know each other, really at all. The only time, as they both testified to, that they had ever spent appreciably together prior to January 29, 2022, is when Mr. O'Keefe nicely took them out for sneakers because he had some sort of deal at a Reeboks outlet or something like that to sort of try to pay them back for the help that they provided him and the children. Jennifer with respect to the niece, and Kerry with respect to the nephew. But they're both contacted by the defendant in the early morning of January 29th. As Ms. McCabe testified, John was my friend. I love John. He was an amazing guy. At the waterfall, Mr. Alberts said going home to have a drink with his son, Brian Jr., if anyone wants to come. Open invitation to the table. She said to Mr. O'Keefe and the defendant, you guys should come. Both the defendant and the victim indicated that they wanted to come and that they were coming. She describes the phone calls and the text messages that she receives from Mr. O'Keefe, that she's providing directions. She indicates she's providing them directions to go down Chapman. She describes how that is. And you've heard this testimony from a couple of different witnesses as far as the steepness as you're going down going down Fairview of coming off of Chapman. That you first go down a big, steep hill. It flattens out for a little bit, and then you go down a second hill. 2 hills going down on Chapman. Matching the GPS native location and the health data as far as where Mr. O'Keefe's phone is, a half mile away from 34 Fairview Road at the time that his health data is reporting that he's ascending or descending 3 flights of stairs. You hear the testimony from Ms. McCabe as far as the last time that she spoke to Mr. O'Keefe. And she's still trying to provide directions to Fairview because Mr. O'Keefe has never been there before and neither has the defendant, which is further corroborated in Trooper Garino's testimony as far as the vehicle passing by Fairview and then coming back in on the other side, having to reverse direction. But she's giving directions and she indicates that she uses a house that Mr. O'Keefe will be familiar with, that belonging to Bella or Bella's mom. Bella's mom is an ex-girlfriend for a short period of time from a long time ago. However, in the defendant's mind, it's so prescient on her mind that she's still talking about it the next morning or later on that morning when she's riding, going towards Fairview Road with Miss Roberts and Miss McCabe in Miss Roberts' car. She's still talking about that at that time. It's that much on her mind. Miss McCabe indicated that she looked out and she saw the vehicle initially in front of the front door, as did Mr. McCabe, as did Brian Albert Jr., as did Julie Nagel, as did Ryan Nagel, and the vehicle moved up several times or several spots to where it was then positioned. Initially at some point in front of the door, then it moves up further so that it's in the area of the fire hydrant and the flagpole where Mr. O'Keefe's body was discovered later on that morning, at least by Miss McCabe and Miss Roberts, and then moves up further beyond that. And I say that in the sense of it moves up further beyond that with sufficient distance for it to then go in reverse for 62.5 feet at 24.2 miles per hour, striking Mr. O'Keefe and leaving him where he was found later on the 29th. Again, the testimony from Ms. McCabe that about 12:40 when she's texting him, she indicated in her testimony she couldn't be certain if Mr. O'Keefe was still out front or had left at that point. She wakes up to a phone call from John's niece Kaylee at 4:53 in the morning. This is from an 8th grader, 14-year-old girl. That's why she answers the phone at 4:53 in the morning. She then hears the defendant screaming loudly over and over again, "Jen, Jen, Jen. John didn't come home, got in a fight, left him at the waterfall." The variations, the different iterations of that story as it evolves and changes over the course of that morning. Ms. McCabe then indicates to the defendant, "We saw you outside of my sister's house." Then she starts yelling, "Jen, Jen, did I hit him? Could I hit him?" Then they start discussing, or the defendant brings up her cracked tail. And then both Ms. McCabe and Mr. McCabe hear the defendant screaming outside of their home at about 5 o'clock in the morning, or shortly after 5 o'clock in the morning. They go to Mr. O'Keefe's house. And both Ms. McCabe and Ms. Roberts indicates, and you heard this testimony from a number of different witnesses, friends and family of Mr. O'Keefe, that he had a rule, pretty strict rule in his house as far as you take your shoes off when you come in the house. And so what did Ms. McCabe and Ms. Roberts both do when they're entering in that house on January 29th? They take off their boots, they get out in the snow, they take off their boots in the mudroom, and then they walk in. What did they both indicate that the defendant did that morning when she came back to the house? Walked right in with the shoes. You hear that second voicemail. It's after the defendants arrived back at One Meadows Ave, after her phone is reconnected with Mr. O'Keefe's Wi-Fi. And you can hear the footsteps. Part of that may be in the garage, part of that might be in the house. Why is it that the defendant has no issue with wearing shoes in the house when Mr. O'Keefe has that strict rule? Because she knows where he is. She knows it's not an issue. He's not coming home because she hit him with her SUV and she left him in the snow. Ms. Roberts and Ms. McCabe are frantically sort of running around the house looking for Mr. O'Keefe. The defendant's not. They then get in the vehicle. They drive back towards Fairview Road, and again, the defendant from the back seat of the vehicle immediately sees the defendant, starts pulling and kicking on the door, and runs in sort of a beeline straight over to where Mr. O'Keefe is laying on the front lawn. You have the testimony from Ms. Roberts as far as John's phone. John's phone, when the firefighters pick him up, and you recall several witnesses testifying about that, pick him up on the scoop stretcher and they bring him over to the ambulance while they're conducting the resuscitative efforts trying to save Mr. O'Keefe's life. But Ms. Roberts indicated that she observed underneath only the phone, but the phone on the grass. On the grass in the area that is completely covered in snow in every other area except under Mr. O'Keefe, which I would submit indicates how long Mr. O'Keefe has been there. Now recall, around 12 o'clock or so is when it starts to snow and it starts to stick a little bit. And you heard all that testimony. And I know it was a lot of testimony about snow and a lot of testimony about weather, but there's a purpose to that. There's a point to that, okay? As far as the grass underneath Mr. O'Keefe's body, where his cell phone was, and Ms. Roberts observes some 6 hours later after it starts snowing, is still visible only under Mr. O'Keefe where his body is, which I would submit as evidence to you as to how long he's been there. Now, on top of that, you also have hours of ring videos of the driveway as far as shoveling and Paul O'Keefe and other people snow blowing and shoveling and all those kinds of things. There's a purpose to that as well. If you look at those, if you look at the video of the defendant crashing into Mr. O'Keefe's vehicle at a speed of anywhere from 0 to 5, which even Dr. Wolf would indicate would not cause the damage to the taillight that was observed in this case. You know what you don't see? You don't see snow move off Mr. O'Keefe's vehicle when they come into contact. You don't see any red or clear plastic pieces in the snow. And if you look at those stills, not the ones that counsel put up there during his closing, but if you look at each of the video in the stills, you can see the damage consistent with the taillight at each and every point. You see the damage consistent with the taillight from the 507 video. You see the damage consistent from the 822 video from Lieutenant Ray from the cruiser camera video when he's pulling into the driveway. You see the damage consistent from the Dighton video at the defendant's home. You see the damage consistent from the right here, February 1st, 2022, when the search warrant is conducted and Ms. Hartnett removes all those pieces from the vehicle. The weather is also important when it comes to the hair. The magic hair, as Mr. Jackson likes to call it. See, the magic hair was actually frozen to the vehicle, as was the glass to the bumper, because the vehicle looked like that on the left when it was caked in snow, when Officer Barrow saw it in the driveway in Dighton as they were wading through 1.5 feet of snow, walking up, because remember, they didn't even pull into the driveway because they had to have someone come down and plow it before they could get into it. That's what the vehicle looked like. What you can see, however, is the damage to the taillight, to the side of that taillight, consistent with it. So that hair, that 7/8 of an inch hair, was frozen to the side. And as you remember, the testimony from Sergeant Buchanan about the heated condition of the Canton Police Department garage, and that's one of the reasons that they took it there, because the other barracks that they could have taken it to didn't have that heated condition. So yes, after it's been in there from January 29th at about 5:30 p.m. until February 1st when they conduct the search warrant, the hair isn't still frozen, as it's contained within heated garage, and the pieces of glass on the rear bumper have melted. The snow has melted, as you can see from left to right. The weather, also important, I would submit, weather was a weapon. Remember, the cause of death here is not just blunt impact injuries, it's blunt impact injuries and hypothermia. And you heard all that medical testimony in relation to it, and you heard all that testimony in relation to the snow and the weather and the wind. Wind gusts up to 37 miles per hour while he's out, Mr. O'Keefe is out there in just a shirt and jeans. Now, you heard also testimony from Ms. Roberts in relation to the injuries she observed to Mr. O'Keefe, that initially on scene, there was one eye that was swollen, not the other. That's indication of the swelling that Dr. Scortibella was testifying to, and no indication of physical altercation. And then both eyes being swollen when Ms. Roberts viewed Mr. O'Keefe's body after his passing at the Good Samaritan. I submit that all the testimony tells you the same consistent account, internally, externally, from civilian testimony to investigator testimony to medical testimony to forensic testimony to the reconstruction testimony. You have the testimony from Ms. McCabe and Ms. Roberts that they couldn't see Mr. O'Keefe at Fairview when they initially pulled up. You can see that from Officer Sarif's cruiser. You have Mr. O'Keefe being covered in snow from the storm. You know where Mr. O'Keefe's body was. It's clearly visible on the cruiser camera from Officer Sarif. You have the testimony from each of the responding officers, anywhere from 5 to 12 feet off the roadway, and from the civilians as well. Ms. McCabe, Ms. Roberts, Officer Mullaney has 6 inches of snow on Mr. O'Keefe when he first sees him. Firefighter Kelly says that he couldn't even see Mr. O'Keefe until he was 5 feet away, in the darkness, in the snow, in the blizzard conditions. There's no footprints around the body. There's no drag marks around the body. There's no evidence of anything in relation to Brian Albert and Brian Higgins. Brian Albert and Brian Higgins spent January 28, 2022, traveling to New York City to go to a funeral for another police officer, for another department, who they didn't even know. Traveled all the way down to New York and then came back before the blizzard, only to come back from that to go out drinking, to come back to Mr. Albert's house, to then murder another police officer who they did know, who worked for the same department as them. And then criminal mastermind genius that Brian Albert is, 28 years on the Boston Police Department, he's then going to just leave Mr. O'Keefe's body on his front lawn? Really? That's the conspiracy? What evidence do you have of that? You have statements that the defendant made to Sergeant Buchanan on January 29th. She was willing to speak but didn't want to give too much detail. Conversational tone throughout. She indicated that the night before they had gotten into an argument, something about what was fed to the children, nothing about the detailed arguments and incessant phone calls and everything else that you saw from the defendant and Mr. O'Keefe's phone on the 28th. She indicated that she got to C.F. McCarthy's around 9 p.m., started drinking vodka sodas, the men were drinking beers. When asked where she parked her vehicle, she said she parked on Washington Street across from C.F. McCarthy's, facing northbound on the same side as Waterfall. Same testimony that you heard from Ms. Kolakithis, observing the defendant going over to her vehicle, getting in the driver's seat, and the victim, Mr. O'Keefe, getting into the passenger seat. She said they left the Waterfall, were invited to her residence. She drove her and John to the location in Canton. She dropped Mr. O'Keefe off, did not see him walk into the home. She, being the defendant, stated she made a 3-point turn and then left. When asked about the damage to her vehicle, she indicated to the troopers, "I don't know, it happened last night." June 2022, you have that other recording of that other version that she now has evolved into, as far as stating to Sergeant Buchanan, "Are you aware that John was beaten up by Brian and Colin Albert? We're all in on the same joke, right? John was pulverized and my taillight was cracked." What evidence do you have of that? Mr. O'Keefe never went in the house. You have testimony from Nicole Albert, Brian Albert, Jennifer McCabe, Matthew McCabe, Caitlin Albert, Brian Albert Jr., Sarah Levinson, Julie Nagel, all indicating never went in the house. John O'Keefe's phone never went in the house, from the testimony and the data points that you have from Trooper Garino. You know how Mr. O'Keefe was dressed, and you know the defendant knew that. You have the testimony from Kurt Roberts, Jennifer McCabe, Matthew McCabe, Karina Kolakithis, Nicholas Kolakithis, Brian Albert, Nicole Albert, Brian Higgins, all indicated in their testimony, and the defendant knew, based on her questions to the firefighters the next morning, that Mr. O'Keefe was not dressed for the weather when he left the Waterfall. The weather was a weapon. You have the testimony about the car, the defendant's car being there in front of the house, moving multiple times. You have that from multiple sources. You have that from Matthew McCabe. You have that from Jennifer McCabe. You have that from Brian Albert Jr. You have that from Julie Nagel. You have that from Ryan Nagel. You have the testimony of Ryan Nagel, Ricky D'Antonio, and Heather Maxson. Ms. Maxson indicated she saw a male passenger, female operator as the vehicle was turning. So remember, they're coming towards Fairview at the same time. The defendant, after conducting that reverse or three-point turn on Cedar Crest, is then taking a right onto Fairview, while Mr. Nagel, Mr. D'Antonio, and Ms. Maxson are taking a left onto Fairview. Mr. Nagel indicates that Mr. D'Antonio then flashes lights. During that time, Ms. Maxson can see inside the vehicle. She sees a male passenger. She sees a female operator. They follow the vehicle as they're turning onto the street. Lo and behold, they're going to the same residence. They park. There's nothing in between them and the defendant's vehicle. They indicate that at no time do they see anybody get out of the vehicle. At no time do they see any damage to the vehicle, or it hasn't happened yet. At no time do they see anyone leave the vehicle and go into the house. The vehicle moves up on different successive occasions, as testified to by Mr. Nagel and several others. And then as they're passing that vehicle, Mr. Nagel indicates that he sees a female operator in the vehicle with the dome light on. Now, interesting, when I asked Mr. Nagel, as far as when Julie Nagel came out to the vehicle, did he roll down the window or did he open the door? He indicated he opened the door. And I asked him, what happened when you open the door? What happens when you open the door to a vehicle? The dome light comes on. So there's a reason I would submit, or the inference that you can make, is that no one sees Mr. O'Keefe in the vehicle because that's the moment he steps out of the vehicle. And then they're gone. The Nagels, Ryan Nagel, Ricky D'Antonio, and Heather Maxson drive away from that. We heard the testimony from Julie Nagel and Sarah Levinson, the peanut butter and jelly sandwich conversation they have with Ms. McCabe, which while they're pulling away from the house where everybody's attention is drawn, Ms. McCabe is turned around facing both of them in the backseat. Ms. Nagel is facing Ms. Levinson on the passenger side, looking out the window towards 34 Fairview Road. Ms. Levinson is looking back at Ms. Nagel away from that area, in which Ms. Nagel indicates that she sees a 5 to 6 foot dark blob on the lawn near the pole in the hydrant, which is just where Mr. O'Keefe is discovered the next morning. You have the testimony recalled, and you have text messages in regard to Colin Albert when he gets picked up from Colin.
Mr. Lally, 5 minutes.
Yes, sir. Colin Albert, Miss Allison McCabe, Brian Albert, Nicole Albert, Caitlin Albert, Brian Jr., all indicating that he was picked up around that time at 12:10 a.m. You have the testimony from Chris and Julie Albert, his parents, as far as when he comes home, kisses them goodnight before he goes to bed. You have that testimony in regard to Chris Albert, as far as how John O'Keefe and the defendant come to be at the waterfall in the first place, as far as John O'Keefe and his nephew coming in earlier in the day, getting a couple slices of pizza, what are you doing later on, contained within those text messages. You have the testimony from Lieutenant O'Hara, Lieutenant Tully, Sergeant Mechanic about those items being recovered. And in particular, the items being recovered on January 29th by that search team. What did Lieutenant O'Hara say? The items were found close to the curb. The items were at ground level. 3 feet of snow that they had to sift through in order to find those particular things. The detail or the delay in the recovery of evidence. The photos in the video, most of which you have in evidence, is earlier in the storm. This is before the 18 inches of snow falls down, before there's drifts and 3 feet of snow in places. They found the evidence where it had been at that same ground level, in the grass, under the snow, at 34 Fairview Road. We heard all of the medical testimony, which I would submit is consistent, from firefighter Formati to Dr. Rice. You heard the testimony regarding the defendant's blood alcohol concentration for Dr. Fowler and Nick Roberts, 93 milligrams per deciliter, 0.07 to 0.08% at 9:08 in the morning. You heard Mr. Roberts' testimony in regard to the retrograde extrapolation, 0.13 to 0.29, extrapolating back to the time of the operation. The defendant admits to drinking vodka. It's on the receipts from C.F. McCarthy's and from the waterfall, and you have the witness testimony in the surveillance video in regard to that. The forensic testimony that you have. In regard to the medical testimony, you have the sort of pattern abrasions, the clear plastic that's recovered by Lieutenant O'Hara and Lieutenant Tully on January 29th. The clear plastic that has the dimples on it. No one, not Trooper Paul, not anyone, at any point in time, ever said that Mr. O'Keefe's arm was out like this at the time that he struck him, that he did a pirouette and then flew 30 feet in the air. 12 inches of abrasions that the doctors were, the biomechanical people were talking about yesterday, 12 inches and then 6 inches for the tail end, is easily solved by this. And the dimples on his arm are, that I would submit are consistent with the dimples on the taillight cover piece, are right around this area of the elbow. You have the testimony in regard to forensics as far as Mr. Porto, Mr. Bradford. John O'Keefe's DNA is on that taillight housing, on the housing. His DNA is there to the exclusion as well of Sergeant Mechanic and Trooper Proctor. Mr. O'Keefe's DNA is on the exterior of the broken drinking glass. Mr. O'Keefe's DNA, and only Mr. O'Keefe's DNA, is on his clothing and his fingernails, consistent with Dr. Scortibello's testimony that there is no evidence of a fight or an altercation. There's no one else's DNA under his fingernails. There's no one else's DNA on his clothing. You have the testimony from Ms. Hartman, Trooper Paul, as regard to the damage that they observed, the dent, the scratches, the 7/8 of an inch hair. You have the testimony from Ms. Chart in regard to the mitochondrial DNA profile from that hair being consistent with the DNA profile of Mr. O'Keefe. You have the testimony from Ms. Valier and Ms. Hanley in regard to the microscopic pieces, 1/16 of an inch by 1/16.
You have 1 minute, Mr. Lally. Wrap it up.
Yes, Your Honor. All consistent with the pieces of taillight that are found within his clothing. Ms. Gilman, if I could. 605, this is what this vehicle looks like backing up at that speed for approximately that distance. There's another, years and years ago, started practicing in Norfolk County in Braintree, what is now Quincy, and eventually became a far smarter man than myself, eventually became President of the United States. His name was John Adams. John Adams once wrote, "Facts are stubborn things, and whatever may be our wishes, our inclinations, or the dictates of our passions, they cannot alter the state of the facts and the evidence." What the constellation of the facts and the evidence ineluctably demonstrate here is that the defendant drove her vehicle in reverse for 24.2 miles per hour for 62.5 feet, struck Mr. O'Keefe, causing those catastrophic head injuries, leaving him incapacitated and freezing to death.
Mr. Lally, I have to stop you. You've gone over. Okay.
I literally have one sentence on Joe.
1 sentence I'll give you.
From that facts and that evidence, I would submit ineluctably demonstrates her guilt on each of the indictments before you, and I would ask that you find her so. Thank you.
All right. All right. Thank you. Jurors, I have my instructions on the law I'm going to give you. My guess is it's probably about an hour. I'd like to start it now, but does anybody need a short break? We can take a short break. Okay, we'll come back in 5 minutes.
Jurors, leaving your notebooks under your chairs. All rise, jury out.
You are muted.
All right, the court taking a quick 5-minute break there after exactly 2 hours of closing arguments here in the Karen Read murder trial. You've been listening to those live arguments this morning. And of course, because that was live, we do apologize for some colorful language that was presented to the jury during that. But we did hear from both Adam Lally, the Assistant District Attorney, as well as Defense Attorney Alan Jackson. We are joined now by former Massachusetts Attorney General Martha Coakley with Foley Hoag. And what did you make of both of these? Let's go ahead. We just ended with Adam Lally. What did you make of his closing arguments?
I thought the prosecution's closing was very strong. It was stronger than his opening, I think, and maybe stronger than some of what he did during the trial itself. But he was in command of the facts. I think he focused on a lot of what he needed to and should have with the defendant, her words, her texts, her phone calls, which you heard again, And her relationship with O'Keefe, he was clearly focused on getting the jury to believe she had a motive to do what then he said the evidence showed she did, which was back that car into him and leave him in the snow where he died.
Lally came out, 3 words: I hit him, I hit him, I hit him. 3 times. On the other side, defense attorney Jackson came out with, the prosecution is asking you to look the other way. It seemed as though the defense was leaning into emotion, the prosecution leaning into what they see as the facts. What do you see?
So I also thought the defense did a very strong closing in terms of going through the, in some ways, inspiration from Wizard of Oz, right? Pay no attention to the man behind the screen. And a little bit of Alice in Wonderland, like you're seeing the opposite of what you think and kind of playing with what witnesses said the opposite was true. And he needed to create a reasonable doubt, but he also created a narrative that in some ways the jury has to believe, part of or all of, that someone else killed John O'Keefe. And so now we're at a stage where they've all acknowledged he was killed by somebody, and they have 2 competing narratives. So the question is, was the defendant able to raise enough reasonable doubt, or did the jury discount maybe what he said that they don't believe? Because he cited some of the sloppiness of the investigation, which clearly was there, some of the witnesses. So I think it will be difficult for this jury, or will take a while perhaps for this jury to make this out, because I think both closings were very strong.
We want to get your final thoughts. Should Karen Read be nervous on this day?
I think if I were she, I would at this stage. Given the physical evidence and given the focus on what the prosecution did on her own words, that relationship with John O'Keefe, and that John O'Keefe is now dead. And the jury will not forget that. The prosecution made sure that they won't.
All right, we will see here what the jury decides. The judge will be coming back in just a few minutes to give instructions, and they have a tough task ahead of them.
They do.
All right, Martha Coakley, thank you so much for being with us throughout the morning.
My pleasure.
We've appreciated having you, and we've certainly appreciated your insight during this trial.
Thank you, Martha.
Thank you.
All right, News Center 5 at noon starts right now.
WCVB News Center 5.